We're on the record.
We're on the record in case number 4:17 CR3038, United States of America versus Michael Wayne Parsons. Counsel, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp, Assistant United States Attorney, appearing on behalf of the United States.
And John Vanderslice on behalf of Mr. Parsons.
Are you Michael Wayne Parsons?
Are we on the record?
Yes, we are.
Good morning, Your Honor, or good afternoon. Let the record show that I was just brought in here by force against my will, and the officer directly behind me assaulted me, threw me to the ground, drugged me in here. I've got broken ribs, broken arm, multiple injuries from previous assaults, and I just sustained another one by this gentleman behind me. I want that to be on the record, first of all. Also, the fictitious person and the birth certificate have been surrendered to the court. And
Please stay seated. You must stay seated.
Birth certificate there. Let the record show that by special appearance, Ambassador Parsons of the Chilcotin Nation, country of the Chilcotin, the beneficiary, I'm here and I reserve all of my rights without prejudice, UCC 1-308, the Vienna Convention on Diplomatic Relations, and the Montevideo Convention, having already surrendered the fictitious person and birth certificate into the well of this court. This court lacks jurisdiction, and I have no business with this court. Am I free to go?
No.
I will instruct you as the trustee to dispose of the charge, pay off any debts, and compensate me for the damages.
Are you Michael Wayne Parsons?
I am not the fictitious person that you seek. You're seeking, according to this affidavit, a corporate entity, Michael Wayne Parsons. I am not that person. I'm not the fiduciary, surety, or trustee for that corporate entity or trust.
All right.
I'm a live man. This court is not an Article III court. As an ambassador of another country, according to the Constitution, Article 3, Section 2, all matters pertaining to ambassadors, the original jurisdiction and sole jurisdiction is with the Article 3, Section 2 Supreme Court. This is not that. This court lacks jurisdiction.
All right. Are you saying you are not Michael Wayne Parsons?
I am not the person in the indictment. That is a fictitious person.
What is your
I'm
name?
saying.
What is your name?
I am Ambassador Parsons of the
Okay.
Chilcotin Nation, country of the Chilcotin. I am not the person, the fictitious person that is in this indictment. That is not me.
All right. Now, Ambassador Parsons, what is your first name?
I'm referred to as Ambassador Parsons for the record.
All right.
I do not consent to this forum. I do not understand this forum. This gentleman just approached me moments earlier, and I tried to ask questions. He could not answer any of the questions.
All right. What I'm going to do is, first of all, we'll have to have an identity hearing, and interestingly, my understanding is that you have refused to be processed by the marshals, which would include your DNA and your fingerprints. You are hereby ordered to submit to processing by the marshals. They will go ahead and do that, even if it's necessary to do it involuntarily.
I would like to be heard on that matter. I don't consent to that under the United States Supreme Court ruling under Title 42, 2000 BB, the Religious Freedoms Restoration Act. It is against my religious objections. I do not do TB shots, or I do not do any unknown foreign substances into my body, and they're trying to force a TB test upon me is in violation of United States Code and Supreme Court rulings that say that if I'm not symptomatic, they can't force me against my will. I've never done a TB test. I don't consent to those now. It is against my rights as a human being given to me by my Creator not to give up my DNA, which is in violation of the Fifth Amendment also, and it's in violation of the Universal Supreme Court Act of the Chilcotin Nation. I am not subject to the jurisdiction of this court. This court does not have jurisdiction over me.
The court does have jurisdiction over you. You are hereby ordered, and the marshals are hereby ordered, to process you, which would include the DNA and would include the fingerprinting and any other matters, and photographing, I assume.
I do not consent to this offer.
It doesn't make any difference.
I do not consent to this offer. I do not accept your offer. And I
It's
do
not an
con-
offer, it's an order.
an order is an offer. I do not consent to these proceedings.
All right.
I am the beneficiary, the living soul. I am not the corporate fiction. And this is after a corporate fiction. I'm a live man.
At this time, though, I am going to have Mr. Sharp advise you of what the charges are against Michael Wayne Parsons and the possible penalty on those charges. Mr. Sharp?
Mr. Parsons, the grand jury seated in the District of Nebraska has returned a one-count indictment that charges you in that count with being a convicted felon in possession of a firearm, specifically described AR-15 rifle and over 600 rounds of ammunition. If you are convicted of that offense, it's punishable by up to 10 years in prison, up to a $250,000 fine, or both. There could also be up to a 3-year term of supervised release that could be imposed after any period of incarceration. Lastly, in the event of your conviction, there would also be a $100 special assessment that would be applied. Do you understand what you're charged with and what the possible penalties are?
I don't understand any of this because I'm not the Michael Wayne Parsons that you're seeking. That is a corporate fiction. And you said that you're referencing an AR-15. That's not what's listed in this sheet of paper in front of me for that corporate fiction. So you're reading into the record things that do not exist on this indictment. I object to the reading of this indictment that is fraud because Mr. Sharp did not read it as it is written.
All right. I'm going to advise you of your constitutional rights. You have the right to remain silent. What that means is you do not have to say anything about the charges in any court proceeding. You do not have to provide a statement to the government or anybody asking for information on behalf of the government. If you've already provided a statement, you do not have to say anything more. And if you ever start answering questions, you can stop answering those questions at any time. But you need to understand that what you choose to say to anyone other than your lawyer can and will be used against you. Do you understand your right to remain silent?
I don't understand any of this, nor do I waive any of my rights. My rights are not constitutional. They come from my Creator God. They're recognized by the Constitution. The Constitution doesn't give me anything. This government doesn't give me anything.
Do you understand that you can remain silent if you want to?
I don't understand what you're doing because you don't have jurisdiction.
All right. You have the right to counsel, and if you cannot afford counsel, counsel will be appointed for you at no cost to you. Do you want an attorney?
I don't waive any of my rights.
Do you want an attorney? It's a yes or no question.
I don't waive any of my rights.
All right.
I don't understand what you're doing. That's the point of this whole matter is you're trying to bait and switch me from counsel to an attorney. They're two different things. Legal counsel and an attorney are two different things.
The only people that can represent you in this court as counsel are attorneys.
What form of court is this?
This is the United States District Court for the District of Nebraska.
And what form of court?
The United States District Court for the District of Nebraska.
That's not the form of court. Is this an admiralty court?
No.
Is this a constitutional court?
Yes.
So you're following the Constitution.
When I advise you that you have the right to an attorney, yes.
Do you recognize Article 3, Section 2 as an ambassador? You
I'm
don't
no
have
longer
jurisdiction
answering your
over me.
questions, sir.
You're not following the Constitution if you're not recognizing Article 3.
I'm no longer answering your questions, sir, and I'm no longer listening to bogus arguments.
Then this court is rogue and it's a fraud. Everything that you do
can
from
take
here
up
on,
in
you're
motion.
violating international law. You're committing war crimes right now by holding me. Now that you know that I'm an ambassador, you're holding me against my will. You're committing international war crimes. I have here a document proving my position as an ambassador of the Chilcotin Nation signed by the hereditary Grand Chief Stanley Stump Sr. himself from January 1st, 2016, before the alleged charge against this fictitious entity. Ambassador Associate Justice Michael Parsons of the Chilcotin Nation, member of the Chilcotin National Congress of the country of Chilcotin, formerly British Columbia, Canada. Michael Parsons is not a U.S. citizen. Michael Parsons has diplomatic immunity based on the appointment to the position of ambassador by hereditary Grand Chief of the Chilcotin Nation, country of the Chilcotin, Stanley Stump Sr., on January 1st, 2016, and based on the Vienna Convention on Diplomatic Relations, Article 39, which states that upon appointment by the country to the position of ambassador, they are recognized and have diplomatic immunity. Ambassador Michael Parsons has been exonerated of all prior convictions and charges from the United States by the Universal Supreme Court of the Chilcotin, which under the rules of reciprocity and the Constitution of the Chilcotin Nation and National Congress must be upheld by the United States. And under Title 28, Section 1330, the United States is bound to uphold that order. Therefore, based on all the above, I, Hereditary Grand Chief Stanley Stump Sr., request immediate release of Ambassador Michael Parsons from detention in accordance with the Vienna Convention on Diplomatic Relations. I have a copy of my tribal card, my status card. It's blown up so that you may see it, and it clearly lists me as the ambassador of the Chilcotin Nation. I will enter that for the record, along with a copy of the letter from the Grand Chief Stanley Stump Sr. himself.
All right. You have the right to a jury trial. At that trial, you'll have the right to see and hear any witnesses who testify against you and to have them cross-examine on your behalf. You'll have the right to call witnesses for you, and if they will not come voluntarily, you can get a court order called a subpoena to make them come and testify. At the trial, you can testify yourself if you want to, or you can exercise your right to remain silent. If you remain silent at the trial, the jury will not be allowed to consider will not be allowed to consider your silence in deciding whether you are guilty. And at the trial, the government will not get a conviction against you unless it is able to prove to every single juror that you are guilty beyond a reasonable doubt. This case is set for I'm going to enter a not guilty plea on your behalf. This case is set for trial, for a 5-day trial before Judge Gerard for February 20th. I'll order reciprocal discovery under Rule 16 to be exchanged within 14 days of today. Pre-trial motions need to be filed by January 17th. Any reason not to otherwise adopt the normal progression schedule, Mr. Sharp?
No, Your Honor.
Judge, I'm going to be out of the office during the week of February 20th, and I presume that we're going to have a jury trial. Would it be possible to move this up a week or two?
Sure. Actually, he is not requesting counsel, so I'm not sure that...
I have not waived counsel. I demand to maintain all of my rights. I've not waived anything.
Then you are appointed as counsel, and you'd like it earlier than that.
I would, Judge.
The
Yes,
problem
please.
we have is this gentleman has already told me he doesn't want this case. He said he's got plenty of cases, doesn't want this case because of the publicity, apparently.
I don't think it's because of that. How about February 12th?
That would be great, Judge. Thank you.
I have no confidence in this individual. He has not given counsel.
Actually, could we go to February 5th?
Sure.
Because I suspect that even though it's scheduled for a 5-day trial, it may take longer.
Yes. February 5th. That sounds like a wonderful time.
Thank you.
One problem we also have is that the state has not shown any proof of a bond in this matter. Does the state have a bond in this matter?
No, that brings us to the issue of detention. What is the government's position?
No, not that
Your
bond.
Honor,
I mean the
I'm
bond
asking
for
the
the
court to take
charge.
judicial notice of the pretrial services report. We are requesting detention both on flight risk and on danger to the community. In addition to what's in the pretrial services report, I would proffer to the court that prior to the events that led to the instant indictment, Mr. Parsons was awaiting trial in Tennessee on release with a bracelet which he cut off. Boarded a
Facts not in
plane
evidence.
and
Objection,
intending
Your
to
Honor. Those
fly
facts are not in
to
evidence.
the country of Canada when he stopped here in the state of Nebraska.
None of those
All of
facts.
those reasons we are asking for detention.
None of those facts are in evidence.
This
There's
is what
nothing in
we're
evidence
going-
to support that. That is not true.
This is what we're going to do.
There was nothing cut off.
If you'll allow me to speak, I am in charge.
Ma'am, I have a wife and a farm.
It doesn't make any difference how many wives you have or how many farms you have. The
Just
issue,
one for 33 years.
The issue for me is whether you pose a risk of flight and a risk of danger to the community if you are released. We're
I've never
looking
harmed-
at having a detention hearing. I'm looking at having that. And then also, we have to deal with this TB test issue. There is, Turner versus Safely gives you the 4 factors that I have to look at in determining whether I can order the TB test. I also need to find out from the marshals what their policy is, what the purpose of the policy is, what alternatives we have, those types of things. And so I'm kind of looking at doing the detention hearing on the afternoon of the 20th. Does that work?
Of December.
Yes.
Yes.
Okay.
And Your Honor, if I could, I don't know if you can see this. I'm going to
Judge, the 20th, Wednesday at, what time are you?
I'm looking at 2:30. Does that work for everyone?
Yes.
Yes.
Okay. We'll do a detention hearing at 2:30, and I'd like to cover the TB issue at the same time. Between now and then, the marshals are entitled, if they choose to place him in segregation under the 8th Circuit law, that you cannot, under 8th Circuit law, you cannot expose other people to potential risk of tuberculosis inside of a penal institution. And if that is a concern for the marshal or for the Saline County Jail where he is being held, you may place him in segregation until we make a decision as to the merits under the Turner versus Safely criteria.
And currently I'm in segregation, and that's being addressed, Your Honor. And I do have with me a copy of my ordination. I'm an ordained minister, Native American minister, and the fact is that I've never done a TB test. It is against my religion. I don't do any drugs, shots, nothing that I know is harmful. And the manufacturer of that shot does not, they state, they do not guarantee the safety or effectiveness of it because they can't guarantee what they put in there. That's the manufacturer. And
so your concern is about the shot itself and the pinprick test itself, is that correct?
I don't put anything into my body that
Okay.
is potentially harmful or is not helpful. I've never done a TB test for that very reason. And the fact is that I've been locked up in the county jail in Phelps for 30 days, in LCC up the road here for going on a month and a half. And they had me in isolation for 10 days. They recognized, okay, he's not symptomatic. I went into general population. In Tipton County, they know that I don't do these shots straight into general population. In the West Tennessee Detention Facility, I was in segregation, not so much because of the TB shot, but because of this false accusation of a flight risk. If Your Honor looks at the record, you'll see that on the false charge in Tipton County, the hearing that I did not attend was because I never had a directive to appear. Prior to that, for going on 2 years, every month I would show up in that courtroom like clockwork. I was out on a $500 bond. I live in the community with my wife. I've got a farm. We're easily accessible. The only thing is that they never gave me an order or directive or anything. I had no indication I was supposed to appear on that day. Otherwise, I would have been there. I was working in my ministry with the Chilcotin Nation, working to help them get a timber deal so they can get their kids back from the foster system.
All right. And Mr. Sharp, I'm also, by then we should have the DNA fingerprints, those types of things. So let's do the identity hearing fully as well on Wednesday afternoon at 2 o'clock.
Judge, I have one last issue. If I could pass this up to you. It's a letter that I tried to get faxed to you last week. I do have a suit, regular clothes, as opposed to this. If I could request the graciousness of Your Honor to allow me to be in proper dress.
Everybody who is detained that comes before this court, this is their proper dress, and so you will be wearing that. Anything else that we need to take up at this time?
No, Your Honor.
No, Judge.
We are in recess.
Would you like me to put your papers back in the envelope for you?
Yeah, Aaron's going to get your file.
We're on the record.
We're on the record in case number 4:17 CR3038, United States of America versus Michael Wayne Parsons. Counsel, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp, Assistant United States Attorney, appearing on behalf of the United States.
And John Vanderslice on behalf of Mr. Parsons. Judge, may I take up a preliminary matter?
Sure.
Before we go into anything else. I've spoken with Mr. Parsons about representing him, and I believe that there is a concern related to me entering my appearance and subjecting subjecting him to the jurisdiction of the court. I've talked with Mr. Parsons about, for lack of a better way of saying it, about how he's playing his cards. Of course, he's perfectly entitled to have whatever beliefs that he feels are appropriate for his case and for life, as far as that's concerned. But I've told him that there are traditional ways of doing things on criminal cases in federal court in Nebraska, and that there are untraditional ways, such as what I perceive he's doing on his case. And I told him I've represented folks in the past that are tax protesters, posse comitatus, challenging the jurisdiction of the court, claiming UCC violations, things of that nature. And I told him that what I have seen in that regard over the years is that folks who play their cards that way related to moving forward on their case typically fare very poorly in the criminal justice system. I've told Mr. Parsons that I respect his position to be able to present his case in any manner in which he chooses, but I disagree with the way in which he wants to do it. One of the concerns that has been raised is that if I object, if I participate in the court hearings in the more traditional way, that it subjects him to the jurisdiction of the court. And as a consequence, I think that it's Mr. Parsons' position that he doesn't want me to do anything on his case. And in fact, he said just a short while ago that that's what I've been doing anyway, is nothing. And so I want the court to know, after our first court hearing 2 days ago, and then today, after having a chance to meet with Mr. Parsons, that I don't think that we have a good attorney-client relationship. I don't see that getting better. And I've told Mr. Parsons that he has the absolute right to represent himself, which may be in his best interest. He tells me that he's never asked for the court to appoint counsel for him. And I said, well, that's probably true. I said, typically the way that it's done is that the court gets a financial affidavit from a person just to determine whether or not they can afford their own lawyer, and that's never been done on his case. And I told him typically what happens in the traditional way, that Ms. Baer, the person sitting in the front of the courtroom, does an interview with the person to see whether or not they can be released, but because he's got the Tennessee case that he owes time on, that isn't going to happen in this situation. So at this point in time, with that preface, I'm moving to withdraw from Mr. Parsons' case as his legal counsel.
Okay. My memory from the other day is that I said he had not requested counsel, and his response was, I'm asserting all of my rights, which I interpreted to be a request for counsel, and so I did appoint you. However, under the circumstances, you can withdraw as his counsel, but you are appointed as standby counsel. All right? Do you understand?
I do.
I would object to that, because standby counsel is no counsel at all, because I wouldn't have the first idea of what to ask him for him to be able to respond. With standby counsel's only duty to respond to questions, if I don't ask the right questions, I'm at a huge disadvantage. And
then figure out if you want an attorney or not. You haven't asked for an attorney. Until you ask for an attorney, fill out a financial affidavit, you're not getting an appointed attorney. If you don't want an attorney, that's fine.
Okay,
if you do want an attorney, either hire one or fill out a financial affidavit, but you can't have it your way all the time.
Okay, well, I find it interesting that you appointed someone without... I was brought in here Monday, and I didn't know anything about the arraignment until I was brought here. I was given no advance notice, and if I could, there's some questions I've got regarding this whole matter.
No, I'm in charge of this hearing. The hearing begins at this point in time.
Well, can I be heard?
No.
Do I have a right to be heard?
No.
I don't have a right to be heard?
You'll be heard at the end when I get done with the list of things that this hearing is noticed for. The hearing is noticed for an identity hearing, a hearing on the motion to compel, and a detention hearing.
That's
And
what
so at
today
this
is.
time, Mr. Sharp, you may proceed. I'd like to hear about the identity hearing first.
Your Honor, the United States would call Monty Chaplesky to testify.
Mr. Chaplesky?
Please state your full name for the record and spell your last name for me.
My first name is Monty, M-O-N-T-E. My last name is Chaplesky, C-Z-A-P-L-E-W-S-K-I.
Thank you. Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Your Honor, may I ask to have access to a pen to be able to take notes with? And
Yes.
Thank you. The ability to actually write stuff down, because right now I'm shackled as such that I can't even barely pick up my glasses.
Okay, it'll take a minute. I'm going to get another key to get that. Okay? So just
My first-
the first couple minutes.
Yes, you may.
Get your handcuffs off here. Are you right-handed or left-handed?
Right.
You may proceed.
Thank you, Your Honor.
We did swear him in, correct? Okay, you may proceed.
Sir, can you tell us who you work for?
I'm a special agent with the Federal Bureau of Investigation.
How long have you been so employed?
I've been employed with the FBI for approximately 16 years.
Where are you currently assigned?
Grand Island, Nebraska, resident agency.
Does your area of geographic responsibility also include Arapahoe, Furnace County, Nebraska?
Yes, sir.
Have you been involved in the investigation that led to the That's okay.
You may continue.
Mr. Chaplesky, have you been involved in the investigation of the matter that eventually led to the indictment of one Michael Wayne Parsons?
Yes, sir.
When were you brought into the case?
I was brought in approximately January 11th or 12th of 2017.
Okay, and how is it that you were brought into the case?
We were brought into the investigation through contact. The FBI Memphis Field Division had contacted our office requesting assistance in locating a fugitive,
And the name of that fugitive was what?
Michael Parsons.
Why is it that the Nebraska FBI offices were being brought into the case?
During the course of the investigation that FBI Memphis was conducting, there were current charges pending in state court in Tennessee against Mr. Parsons. Mr. Parsons had failed to show up for his appearance, and a warrant was issued subsequent to that. There were the FBI Memphis employed some techniques to utilize to try to track and locate Mr. Parsons. That location was near Arapahoe, Nebraska.
All right. Did you actually participate in the arrest of the individual known as Michael Wayne Parsons?
Yes, sir.
What was the date of that?
That was January 12th, 2017.
And where was that at?
That was at the Arapahoe, Nebraska airport.
Okay. And did you personally see a person that was taken into custody that day?
Yes.
Do you see that individual seated in the courtroom today?
Yes, sir.
Can you point to where he's seated and describe what he's wearing?
It would be the defendant, Mr. Parsons. He is wearing an orange pant and shirt. He has glasses, long black hair, and a mustache.
Your Honor, may the record reflect the witnesses identified the defendant?
It does.
And did you obtain a name or any identifying information from Mr. Parsons on the date that he was taken into custody?
Yes, sir.
Was it given to you orally or through some documentation that had been seized?
There were documents, to wit, there were several mailings, there were identification cards in Mr. Parsons' immediate location where he was arrested.
First of all, do you have exhibit number 2 in front of you?
Yes, sir.
Can you identify what exhibit number 2 is?
Exhibit number 2 is a photograph of Mr. Parsons, Michael Parsons, that was taken at the Furnace County Jail almost immediately after his arrest and transport to Beaver City, Nebraska.
Okay, and does that fairly and accurately portray the way he appeared on the date of his arrest?
Yes, sir.
Your Honor, I would offer exhibit number 2.
Any objection?
Objection.
And the basis?
Did you take this photograph, sir?
You may answer.
No, sir, I was present.
You were present when this photograph was taken?
Yes, sir, I was present there when you were being processed.
You witnessed this photograph being taken?
I was there when that photograph...
Did you
and your-
witness this photograph being taken, yes or no?
I think he answered the question. His answer was yes.
Did you witness this photograph being taken? He hasn't answered the question. The fact is, he didn't witness this photograph being taken, did you?
Your Honor, I object to that on relevance grounds.
You might have been in the
The question
building.
is whether or not this
might have
fairly
been
and
in the-
accurately portrays it the way he appeared on the date of his arrest.
He might have been in the building, but he didn't witness the photograph being taken, so he cannot identify the authenticity of the photograph where it was taken. That's the
Objection
point.
is overruled. Exhibit 2 is received.
You made reference to the fact that there were also some documentary items that were found in proximity to where the individual known as Michael Wayne Parsons was taken into custody. Do you have exhibit number 3 in front of you?
Yes, sir.
And can you identify what exhibit number 3 is?
It is a photograph of an identification card that states country of Chilcotin identification.
Okay, and does it have a person, and I'm not asking you to read off of it just yet, but does it have a person's name on it?
Yes, sir.
And does it also have a photograph of someone?
Yes, it does.
Have you seen this item before today?
Yes, sir.
Where did you see it before?
At the scene of the arrest.
Okay, specifically where?
It was on a table that was laid out on a table as items were being photographed.
Judge, can I have just a moment, please?
Certainly.
Sorry.
Thank you.
Was that in the same room where Michael Wayne Parsons was taken into custody?
Yes, sir.
And does that fairly and accurately portray that identification card that you've described?
Yes, sir.
Is it correct that there's also another item that is reflected in there?
Yes.
And what's the other item that's reflected in there?
There is, looks like there are a Walmart gift card, Sam's Club possibly, and then a receipt. It looks like a receipt. I can't exactly tell what it's for.
Of the items that are in there, the one I specifically want to ask about is the Chilcotin identification card. Does that fairly and accurately portray the way it appeared on the date of its seizure, other than the fact that it's in black and white?
Yes, sir.
I would offer Exhibit 3, Your Honor.
Any objection?
And you identify this card as one where it
Any?
lists...
You need to answer my question. Any objection?
Objection.
What is the basis of the objection?
How did you obtain this photograph?
What is the basis of the objection? You have to give me a evidentiary basis for the objection.
I don't believe he's actually identified how he obtained the photograph.
He need not do so. That is not a requirement.
If I don't know when and how the photograph was taken, I don't know if it is relevant to this case.
Any other objections? You've raised relevancy and foundation. Anything else? Objections overruled. Exhibit number 3 is received.
You've made reference to the fact that this has some writing on it, and just for clarity in the record, how is the nature of the document described on Exhibit number 3?
The nature is it's stating that it's an identification card in a person's name.
Issued by what issuing agency?
By the country of Chilcotin and the Chilcotin National Congress.
And is it correct that in the bottom right-hand corner there's a photograph?
Yes, sir.
Do you recognize who's portrayed in that photograph?
Yes, sir.
Who is that?
That would be Michael Parsons.
And is he in fact identified by name on that document?
Yes, sir.
As in what capacity or by what name?
Michael, M-I-C-H-A-E-L, Wayne, W-A-Y-N-E, Parsons, P-A-R-S-O-N-S.
Does he have any official designation that's listed on that card?
Yes.
What is that?
It states that the position is ambassador/justice/diplomat.
Is it correct that as part of this investigation there was a search warrant that was seized at a later time?
Yes, sir. The search warrant was served at a later time.
How much later?
That was, as I recall, I believe that was approximately a month and a half later, roughly.
Okay, where was it executed?
It was executed at the Arapahoe Airport in the north hangar.
Specifically within anything contained in that hangar?
Yes, sir.
Where's that?
That was inside of a Piper, I believe that was a Piper aircraft, a 1964 Piper aircraft.
Why did you seek a search warrant to search that aircraft?
We had developed information leading us to believe there was probable cause to believe that there were firearms in that airplane, as well as possibly documents that would have shown travel to Canada, as well as documents relating to the Chilcotin Nation.
Had you, during your investigation, had you developed any information that tied Michael Wayne Parsons to that airplane?
Yes, sir.
Where did you get that information from?
The initial information came from the FBI Memphis office when Mr. Parsons was not located when he didn't show up for his state trial. When the information was passed to FBI Grand Island, it was not known at the time of his arrest, that he was in an airplane. That information was not known to law enforcement. When it was found out later, I believe that day of the arrest, that he was in that airplane, FBI Memphis then started tracking and trying to obtain documents from both the FAA as well as the previous seller of that. So they conducted an interview of the previous seller of that aircraft.
Do you remember that individual's name?
I'm sorry, I don't.
Did he identify who it was that the airplane had been sold to?
He identified Michael Parsons.
Okay. Did you also conduct any other interviews that tied Mr. Parsons to that airplane?
Yes, there were. I conducted an interview of a gentleman, as I recall, by the name of Stephen Sweat. I believe it was S-W-E-A-T, who, as I recall, had helped purchase or fund the purchase of that airplane with Mr. Parsons.
This was an investigation that ran for a few months, is that correct?
Yes, sir.
Did you also talk to an individual by the name of Anthony Todd Waverka at some point?
Yes.
Who is Mr. Waverka?
Mr. Waverka is a citizen of Arapahoe, Nebraska, and he held several positions in local government. He was a local postal carrier. He was also the president of the Arapahoe Airport Board or Airport Authority.
Did Mr. Waverka explain to you how it was that Mr. Parsons had arrived at the Arapahoe Airport?
Yes, sir.
What did he tell you?
Mr. Waverka told us that approximately 2 weeks prior to Mr. Parsons arriving in Arapahoe, that he had communicated that Mr. Parsons had reached out to him, inquiring, I believe, as I recall, I think just about refueling and storage, which is certainly within the position that Mr. Waverka held. Mr. Waverka met Mr. Parsons when Mr. Parsons flew into Arapahoe, and then actually took him into town to buy some supplies and a cell phone, I believe.
Did Mr. Waverka report to you which airplane it was that Mr. Parsons had arrived in?
Yes, sir.
What did he tell you?
That was the plane that he indicated was that same plane, I believe it was a 1964 Piper aircraft. It's a small single-engine aircraft.
Okay, the same one that the search warrant was executed upon, is that
Yes,
correct? Sir. And is it Well, was there anything of interest that was seized during the execution of that search warrant?
Yes.
What's that?
There was an AR-15 style, .223 caliber rifle with several firearms accessories, scope, light, sling. It was located inside of a bag. There were several hundred rounds of light armor piercing ammunition as well.
And is it that firearm that is the subject of the indictment that Mr. Michael Wayne Parsons is charged in?
Yes, sir.
And that being the same Michael Wayne Parsons that's here in the courtroom today, is that right?
Yes, sir.
I have no other questions on the issue of identity, Your Honor.
All right. Mr. Parsons?
Did you actually interview Anthony Todd Weaverick yourself?
I have interviewed Mr. Waverka. Yes.
I'm sorry, how do you pronounce it?
Waverka.
Weaverka.
Yes, sir.
Okay. And you have interviewed him?
Yes, sir.
Okay. Did he ever tell you that he ever saw me in this plane, or just that he saw me there at the airport and there was a plane there?
I don't recall him ever stating that he saw you in the airplane. No, sir.
Okay. And it was, you said a month later when you received the search warrant, roughly February the 12th?
That I didn't state February 12th. I believe I said it was a month and a half roughly. I would have to look at the exact dates of the search warrant.
Do we have a copy of the warrant here by chance?
No, we do not. I do not.
I do, Your Honor. I guess I would object to that. I think the only issue we're talking about here is whether or not he's the person who's the subject of the indictment.
Well, the fact that he's bringing up all the contents of this plane and trying to allude to somehow me being responsible for the contents of the plane is at question here, and that's what I'm trying to bring out as the agent, detective.
I'm a special agent, sir.
Special agent has referenced. The interview confirmed that I was not actually in the plane, never seen in this plane, though I was there at this airport. There was a plane there. When that plane was loaded or unloaded is a question, and tying me to this contents of this plane is the heart of this matter that is not going to be solved without proper identification as to...
I think as to the issue that's in front of us right now is the identity issue as to whether you have objected and said that you are not Michael Wayne Parsons, and the question that is currently before the court that we're having the hearing on is whether you are.
Well,
Can you explain how how looking at the search warrant is going to answer or respond to that issue?
Well, it would give me a timetable to look at how much time elapsed from the time that I was arrested to the time they found whatever it is they claim they found. I think the witness has already testified that he's recognized, which I've shown this court before, this is a larger copy of what you have as an exhibit. This is a copy of my identification card, which clearly identifies me as the ambassador of the Chilcotin Nation's country of the Chilcotin. And the reason I emphasize that is that the country of the Chilcotin is within the Chilcotin Nation, as such as if this room was the Chilcotin Nation and this table is the country of the Chilcotin's territory. For that purpose, is that, and you read through it, it's a small version, but this is a larger version. It's the same thing. And it clearly indicates my position.
Okay, let me ask. I think we can shortcut this. I think all you need from this is the date. Can you give me the case number, Mr. Sharp?
I can, Your Honor. Just did that.
I think I can get you from the court's docket the date of the warrant, and that is what you need off of it. And I can say I'll take judicial notice of the date of the warrant, and I'll give that to you, and then we'll have this resolved. The date of the warrant. Just tell me the case number, and then I can look it
Right.
up.
The reason I'm only going this far, ma'am, Your Honor, is simply because the relevancy to the contents of the plane and identification are totally remote.
Yeah,
Identification.
and I understand your argument being that you need the date, and so
Your Honor, the date that...
case number.
I'm sorry, the case number is 4:17 MJ 3029.
Okay, just one moment. The date of that warrant was issued was March 20th of 2017. The warrant returned. The warrant was executed on March 27th of 2017, and the warrant return was provided to the court on March 30th of 2017. I believe that answers that particular issue for you, sir.
May I be provided a copy of this warrant?
It's not relevant to this particular proceeding. The
No,
dates,
that's the whole point. It's not, the warrant and the contents of the plane, none of that is relevant. I agree, totally. It's
the
not.
dates are what you said you needed, and I've provided you with the dates. You may proceed.
I would move that the court strike all the information regarding the plane and the content of the plane, since the court's already agreed that it is irrelevant to this identification.
It's not probably going to be irrelevant to the next portion of this hearing, which is the detention hearing. May I take you to, we can either put the two hearings together or not.
I would say they're two separate issues, simply because identification is one. And the point of me bringing this up is that the indictment is against an all-capital letter juristic person. The U.S. Printing Style Manual clearly says that in all courts in this United States of America, any name in all capital letters indicates a corporation or a trust, not a live human being. I'm a live human being. This is an upper and lower case, is it not, sir?
You may answer his question.
I'm sorry, I don't know if I can read everything from there, sir.
May I pass this up to the witness, please?
The courtroom deputy will assist you in bringing it up to the witness.
Oh, I'm sorry. Thank you.
Did you want it marked as an exhibit, sir?
No, ma'am.
Okay.
It's a duplicate of what they've already got as an exhibit M3. It's just a larger version, but it's just for... All I'm trying to just point out is that the name is clearly an upper and lower case, which is indicative of a live human being. And what the court's indictment is presenting is for a corporate entity or a trust. Otherwise, it would have that name listed in upper or lower case. And that is not me. I am not that juristic person. That's what I argued the other day.
So your argument is because the caption of this case is, in the caption lists the defendant in all caps, that makes it something other than a individual person? Is that your argument?
Oh, no, ma'am. No, ma'am. An
Okay,
individual, no, ma'am. An individual person is a corporation or trust. It's not a live human being. That's the point. What you're saying is a corporate trust, and you're absolutely correct. They're coming after a corporate trust. I'm not that corporate trust.
All right. You may proceed with your questioning, sir.
You said you had interviewed Steve Sweat.
I conducted a telephonic interview.
Okay. And Steve Sweat, as you said that he had an interest in the aircraft.
Yes, and I would have to refer back to my interview report for the specifics.
Okay. Is he now in possession of the aircraft?
That I don't know.
Okay. And the contents of the aircraft, have y'all been able to identify how it got there at any point?
Can you be more specific on which content, sir?
Any of it.
Would that be the firearm, or would that be
Anything at all in the aircraft? Is there any way that you have any proof of how it got in the plane?
Are those the documents that are issued? There were documents that were printed out in the name of Patricia Parsons. Are you talking about those documents?
Well, let's start with the gun. Do you know how the gun got in the plane? If there was a gun there, do you know how it got there?
I was present during the execution of the search warrant and the recovery of the firearm.
Do you know how the weapon got into the plane? The alleged weapon, do you know how it got into the plane?
No, sir.
Do you know when it was put in the plane?
Before we executed the search warrant.
Okay, so in other words, you don't know the exact date or time to any certainty. And earlier you said that this warrant was conducted a month after my arrest, which I thought was February the 12th, and now it's actually a month and more later. It's 2 months and days. That's a long time for a plane to sit there without somebody having the ability to get in and out of it. Certainly it seems it's logical that with the The plane was unlocked, I presume. Is that right? Yeah.
Well, first, if I may, Mr. Parsons, you had stated that I stated it was a month. I believe I would have to review my testimony. I believe I thought I said it was close to a month and a half.
Yes, sir.
It was at
That's
some
right.
point in time, so my apologies for being off by another 2 weeks on that. So I can tell you there was a constant dialogue with law
Well, it's
enforcement
actually
there.
It's 4 weeks difference.
I can do the math on the time. Go ahead.
Okay. We were in constant dialogue with local law enforcement about the security of the aircraft, and there were steps that we were taking to try to proactively ensure that the aircraft was secured prior
But
to the
the
execution.
local law enforcement wasn't aware of the aircraft's existence for what, a month or so?
We being law enforcement collectively, and then specifically the local sheriff's office, was informed, I believe it was roughly around the time that you were being processed that we received the information, so it was the date of the arrest that you had flown the airplane to Arapahoe.
Okay, who says that I flew a plane to Arapahoe?
That would be Mr. Waverka. Mr. Waverka approached Sheriff Kurt Kapperman when the sheriff and myself and other agents were at lunch, and pulled Sheriff Kapperman to the side and indicated that he understood that you had been arrested, and that the information was in law enforcement and the circles, the social circles in the town of Arapahoe, was that we in law enforcement were looking for a vehicle. As I recall, I believe it was a gray, possibly a Ford Taurus. Mr. Waverka told Sheriff Kapperman, from what I recall, from what Sheriff Kapperman told me, was that Mr. Waverka said there was no car, he flew an airplane. And that airplane, I can tell you, I had witnessed at the time of your arrest when I went in to clear that hangar for any other persons. So I hope that answers your question.
Okay, so what you just said, I'll rephrase it. If I'm not mistaken, you said that it was actually Sheriff Kapperman that told you what he claims Waverka told him, and not actually Waverka telling you that he ever saw me fly anything. Waverka never told you that he saw me fly anything, did he?
Okay, that's your question, is that the sheriff never...
Did Mr. Waverka personally tell you that he saw me fly anything?
No, sir.
Has
No.
anyone ever told you that they've ever seen me fly anything?
No, sir. Not that I recall.
No further questions.
All right, any redirect?
You interviewed Mr. Waverka very late in this investigation, is that correct?
Yes, sir.
Whether or not he said he had personally seen Mr. Parsons seated in the airplane, did he tell you nonetheless how Mr. Parsons arrived at the Arapahoe airport?
Yes, sir.
What did he tell you?
He told us that he had arrived in that airplane in Arapahoe after previously, I believe, landing in Cambridge, Nebraska, and then flying from Cambridge Airport to Arapahoe.
He being Michael Wayne Parsons?
Yes, sir.
No further questions on this issue, Your Honor.
You may step down.
Redirect, please.
No redirect to my
Well, he
court.
brought up another issue.
No, he didn't. You may step down.
Your Honor, I do intend to call him on the issue of detention, so
Yeah, we're taking these one up at one
Okay.
at a time. So,
that's all I have on the issue of detention, Your Honor.
all right, on the issue of
Identity,
identification, do you have anything further you'd like to say, sir, on the issue of identification? Other than what you said the other day, do you have anything further you want to present on the issue of identification?
Yes, ma'am.
All right?
I have a notice to the court from the hereditary Grand Chief Stanley Stump Sr. This is actually to Tennessee, but it's dated March 12th of 2016, where it identifies me as a Chilcotin tribal member, the associate justice of their court system, an ambassador, and as he put it, as a diplomat and dignitary of the Chilcotin Nation, Ambassador Associate Justice Michael Wayne Parsons is free from the jurisdiction of all Tennessee and U.S. courts. I'd like to present this as an exhibit.
Do you have any others that you'll be presenting? Because I'm going to have Ms. Bierbauer come and collect them all. Any other exhibits?
Yes, okay, yes,
Why
ma'am.
don't we
Would you
just
like-
get them all identified and we'll get them all marked? But
Very
Jerry,
good.
you can stay seated until he's identified them all and then we'll mark them. Okay, you may
Should
proceed.
I reference a number as we go?
You don't have to. We'll put numbers on, and then I'll identify which number went with which exhibit. But go ahead and explain what other exhibits you'd like.
And given the facts that I'm confined to a jail cell without the access to printers and copiers and such, is there any way I can actually get a copy of the file here? Because
Yes.
I've not been provided that as such. I also have a bio that I've had published for some time, and it lists me also as the ambassador of the sovereign Chilcotin Nation, as well as my credentials in my ministry that I've been in. I will include that for identification purposes. The Declaration of a New Country of the country of the Chilcotin, which was issued to Ben Ki-moon, the former Secretary General of the United Nations, was issued by Grand Chief Stanley Stump Sr., and it was I who presented it to General Ben Ki-moon of the United Nations,
All right.
otherwise acknowledging me as their ambassador. I also have for the court a copy of the Chilcotin National Congress's Universal Supreme Court, a reasons for judgment regarding the review and evaluation and expungement of the case from Tennessee, which everything hinged on from 2009, where they did a review and overturned that decision in their international court. The international court in The Hague already has a copy of this. It's taking longer than one would hope. However, initially it has been said that they are of the same mind that I was falsely charged, falsely convicted, when an unknown man to me and my wife shot 29 times at me and my wife and shot and killed our dog right in front of us. And for me yelling at him to stop shooting, to put his gun down, I was charged with aggravated assault and sentenced to 7 years in prison because I dare expose, at least in Tipton County, Tennessee, how they're rigging elections. There's an amended order that is attached that I will also include that shows the response of the court correcting the date from the original order from 2007. It was a typographical error. I would include that as well. Also listing me, at that point, just an individual, just a human being, not a corporate entity, not a trust, and at that time, not a Chilcotin tribal member nor an ambassador. But it was through that observation and verification of the facts in that case, they discovered someone that they could trust that would stand and fight when others would remain seated and not speak out against corruption. And that's why they've adopted me, and that's why they've made me their ambassador, for no other reason than the fact that I'm brutally honest and I'm not trying to hurt anybody but help people. I also have with me, given the fact that I was assaulted the other day when I was thrown into the floor into the courtroom, I have a letter from a physician for me from January 30th of this year, referencing the fact that I had sustained several broken ribs, malnutrition at the hands of the Tipton County Jail while I was incarcerated there for 6 months, lost significant weight, and that given his knowledge of me and the abuses I've suffered over the past several years with Tipton County that he's treated me for as a naturopathic physician, it was his personal opinion that law enforcement officials in Tipton County, Tennessee have a personal vendetta against Mr. Parsons and that his very life could be at risk if he were reincarcerated at one of their facilities. This again identifies me as someone who has been abused by a corrupted government system.
Can I don't mean to interrupt you, but can you explain to me how any of that is relevant to who you are, which is what we're here for right now?
Well, I'm asserting to this court that I am a live man. Corporations and trusts don't have
I
feelings.
don't doubt that. I agree that you're a live man.
That's the purpose of it.
Okay.
That's it. Just in a nutshell, I'm a live man, and a corporation or trust, which is what I'm asserting the United States of America Corporation, which it's a corporation listed on Dun & Bradstreet. I've got the DUNS numbers here. More than happy to display them to the court if they need it. So I know what's going on. And the fact is, I'm not trying to hurt people. I'm just trying to help people stand on their own feet as
Would you
I've
like
stood
the
on
courtroom deputy to have those brought up here so that I can mark them and put them into evidence?
Yes,
Or
and
are you done? Are you
I
not done?
have just a couple more.
Okay.
The next is the Chilcotin Nation Letter of Appointment and Tribal Membership. This is where I was duly appointed as their Associate Justice of their court system, and also made a full tribal member, signed by the Grand Chief Stanley Stump Sr. as well. Next is a letter of declaration, because there's another entity out there claiming to be the Chilcotin National Government. It seems as though groups can create a club and put the word government in their name and expect people to believe that they're in charge. Well, the Chilcotin National Government, on their own website, it lists that they are a society of elected chiefs from 6 other bands within the Chilcotin Nation, and that they're there only to support these other groups, that they do not speak for them. On their own website, clearly says they do not speak for these other entities. They're all independent. That's the key thing. In Native American tradition, it's linear. We're all equal, all of us. No one is above the other. In the white man's world, it's vertical. Everyone has somebody above them that they have to respond to. In our culture, our Creator is the only one above us. That's where this fictitious sovereign citizen colony that the U.S. Marshal Service has hatched comes from. They've accused me and other people that have been adopted into the Chilcotin Nation of being a sovereign citizen group. And that's the biggest lie there is. The Chilcotin are a sovereign people. They're not a colony. They're not citizens. They're not sovereign. Whatever a sovereign citizen is, we're not that.
All right. Do you have any other documents you want to present on the issue of identification?
I have my official birth certificate, which identifies me from the time of my birth in upper and lowercase letters. And it identifies me as a live human being, not a corporation. And as such, this is the document, according to my friend Trey Hargett, who is the Secretary of State of Tennessee,
All right.
that he understands, and I understand what's going on. They've created a trust that funds are drawn from, and that's why it's in all capital letters, because the trust is where the money is. That's what they're coming after, not me. And that's my position, is that the court does not like jurisdiction over trust and corporations. Certainly they do, because the state issues those charters for them to function, but not a live man. This court is a function of a corporation. It is not over me as a live man, and that's why I demand to be released, because the court does not have jurisdiction over live men, but things. I'm not a thing. And the last thing, piece of documentation, this would be an official copy of my ordination as a Native American minister. Again, this shows further my credentials in the Native American community as someone who has studied natural medicine and traditional ways and promotes life. And that's not an easy document to come by. Certainly it may not mean much in this forum. In the Native American world, it's a big thing.
All right. What I'm going to do is have my courtroom deputy gather those from you at this time. I'll have her mark them and put exhibit numbers on them. Is there any objection to any of them, Mr. Sharp?
I would like to see the birth certificate, but for purposes of this hearing, no. Thank you.
Ms. Milburn?
Can you do it that way, Jerry? Just put one exhibit sticker on it so you don't have to mark them individually. Oh, do you? Okay. All right. Yeah, they're mixed. Okay. Yeah, whatever.
ma'am.
With your 10.
Let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, and this would be 10.
Just do them as 101 and put them all together.
But no, I'd like them individually.
You want them individually?
Yeah, that way I can reference them, please. Thank you, ma'am. I apologize, Your Honor. Inadvertently, there was one last document that was somehow covered up. If I may, and it is simply a letter from Grand Chief Stanley Stump Sr. that was written to all United States of America authorities. This court would be part of that. It was written on April 24th of this year, and it references Ambassador and Associate Chief Justice Michael Parsons is a Chilcotin tribal member and member of the Chilcotin National Congress in the country of Chilcotin, formerly British Columbia, Canada. Michael Parsons is not a U.S. citizen. Michael Parsons has diplomatic immunity based on his appointment to the position of Ambassador by hereditary Grand Chief of the Chilcotin Nation, country of Chilcotin. And I should stop here and mention that the nation is Chilcotin, T-S-I-L-H-Q-O-T-I-N. They pronounce it Silcotin. The white man says Chilcotin. They have in turn, because of trying to make peaceful relations with this country as well as others, created the country of Chilcotin, which was the new country served upon the United Nations. And it's spelt C-H-I-L-C-O-T-I-N. That's the way that the white man has spelt the native term Chilcotin for over 100 years. Even in the book that most of us read in the 10th grade, Call of the Wild by Jack London, when it references Buck the dog running through the Chilcotin territory, that's what this is the Chilcotin Nation.
All right.
Sorry, Approach, Judge.
Yes, you may. Thank you. Thank you, Ms. Beerbauer. Thank you, Mr. Vanderslice.
It's sitting right here in front of me. And this was the one that Your Honor will probably want to see. This is the one from the U.S. State Department, or as they refer to it, the Department of State. And this is the confirmation of my A1 diplomatic visa. They have me listed as ambassador and public minister for the country of Chilcotin, Chilcotin Nation. And unfortunately, as you'll notice, they spell the name in all capital letters because the way Washington works, everything they do is in all capital letters. Now, I'm not stipulating that I become an entity because of their writing on this in no certain terms. I'm just clarifying that they have been so conditioned to having everything set up for this corporate trust system that even in their visas, that's how they have it listed, though they recognize that I am not a corporate entity or a trust. That's just the way their system is set up. But this is the printout from their webpage. It's still on the website, but this is a verification of a confirmation of a A1 diplomatic visa with all the numbers attached. And I would also present that as an exhibit of proof of my credentials as an ambassador of the Chilcotin Nation, country of the Chilcotin.
All right.
May I approach, Judge?
Yes, you may. I believe that'll be exhibit number 113. So we have a gallery of people back there that are waiting for their 3 o'clock and 3:30 hearings. I will state, and one of them being rather ill. What I'm going to do is we are going to conclude the identity hearing, take a brief break, let those folks get done, and then we'll finish this up. I happen to know Ms. Milburn is rather ill because she's been ill for a few days. So hang on, we're not quite done with this hearing. All right. Exhibit number 101 is the Chilcotin National Congress number 8296. Exhibit number 102 is the Ambassador Michael Parsons ACJ bio. Exhibit number 103 is the June 20th, 2016 letter from the Chilcotin National Congress. Exhibit 104 is the document filed on January 9th of 2017, which is a reasons for judgment from the Chilcotin Nation. Number 105 is a it's dated, stamped, dated March 20th of 2016, the Chilcotin National Congress document signed by the Honorable Chief Judge. Number 106 is a document signed by Dr. Bradley Frieza, dated January 30th of 2017. Number 107 is the Chilcotin National Congress document filed stamped December 13, 2015. Number 108 is a letter of declaration.
Ma'am, I'm sorry to interrupt. That's 2015?
Yep, it says 2015. 108 is a document signed on March 6th of 2016 by the hereditary Grand Chief of the Chilcotin National Congress. Number 109 is the document dated June 13th of 2013, which is the Indigenous Traditional Organization and Native American Church of Nemanha. Number 110 is the birth certificate of the defendant. Number 111 is the identification card of the defendant that was issued by the Chilcotin Nation. Number 112 is a document dated April 24th of 2017 by the Chilcotin National Congress and signed by its hereditary Grand Chief. Number 13 is a confirmation of non-immigrant visa application. Let's see if it's got a date on here.
I think it's around January
completed.
19th.
It was the document. The confirmation itself was completed on January 19, 2017.
Yeah, it takes them about a month to complete
Okay.
those things.
Any objections to exhibits 101 through 113 for the identification hearing?
No, Your Honor.
All right. Exhibits 101 to 113 are received. Any additional evidence, sir, on the issue of identification?
No, ma'am.
All right. Anything in reply?
No, Your Honor.
All right. I do find that the defendant who is seated here is Michael Wayne Parsons, based upon the evidence that has been presented at this time. We're going to recess at this point in time as to this case number and move on to case numbers, the cases that were supposed to be before me at 3 o'clock and at 3:15, and we'll reconvene as to Mr. Parsons, the detention hearing, and the motion to compel immediately thereafter. We are in recess.
Leave that here. You can take us back.
We're on the record.
We're on the record in case number 4:17 CR 3038, United States of America versus Michael Wayne Parsons. Counsel for the government, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp appeared on behalf of the United States.
And Mr. Michael Wayne Parsons is also present along with his standby counsel. Please enter your appearance as standby counsel.
John Vanderslice is standby counsel for Mr. Parsons.
Objection. I am Ambassador Michael Parsons. I am not the corporate entity or trust Michael Wayne Parsons that the indictment is against.
and I have already ruled that you are Michael Wayne Parsons, the defendant who is named in the indictment. Now we're going to be taking up the detention hearing at this point.
And I would object because I am the live man, I'm not the corporate entity, and the United States printing style manual clearly articulates that in all court documents, names in all capital letters reference corporations or trusts.
All right.
It's an
Mr. Sharp, you may proceed.
Your Honor, if we didn't cover this at the last hearing, I would ask the court to take judicial notice of the pretrial services report and of the testimony of Monty Chaplesky that was given during the identity hearing.
I would object. I've never been provided access to those to review.
Okay, the pretrial services report. Mr. Vanderslice, do you have a copy of that?
I do, Judge.
All right. Pretrial services report, I believe in this case, is essentially your criminal history.
I do somewhere. If you just give me a moment. I'm sure I've got it.
I can...
And, Your Honor, if I may ask, those documents that I presented as exhibits, those are the only ones that I have like
Right.
those. If there's a possibility to get a copy of those...
You will have a copy before you leave the building. I promise.
Okay, thank you.
Mhm.
And other than that, anything in the file,
In fact, what we may do is make a
Mr. Van-
photocopy and keep the photocopy and give you the original, because I don't know if I know how to make color copies.
well, Mr. Vanderslice did give me a couple of copies of things from the file 2 days ago, but it looked like there might be 11 different things filed in there, so maybe I'm missing about 9 of them.
And Judge, I can tell you, I spoke, I'll be happy to provide Ambassador Parsons with all of the documents that I have that have been filed in his case. And I should note that I spoke with Mr. Sharp out in the hallway during our break. He had asked to be able to give me the Rule 16 discovery, and I told him that would be fine as long as I'm able to photocopy that and provide Mr. Parsons actual copies. Typically, there is a prohibition against defense lawyers giving copies of the discovery to our clients.
Okay.
And so here, I just want you to know that that's what I intend to do.
All right. Hang on just a second, sir. I'll give you a copy of your pretrial services.
Actually, I just gave him a copy.
Oh, you did?
My copy, yes, Judge.
Thank you. All right, I will, any reason I should not take judicial notice of the pretrial services
Yes, Your
report?
Honor, I object to this because this says at age 29 that I wrote a worthless check in Tipton County, Tennessee. I was nowhere near Tipton County, Tennessee at the age of 29, and I certainly have never written a worthless check in my life. It says disposition not received, but this is insane.
All right. Anything else on this document that you object to? Candidly, I probably wouldn't go
May I-
back all the way to 1991 and figure out what to do with that information anyway, so.
Here again, it says there's a charge of financial responsibility law. As far as insurance on vehicles, if that's what that's talking about, I don't think I've ever gone a day since I was 17 without insurance on a vehicle.
Okay.
And this issue of aggravated assault with injury, disposition not received, the grand jury dismissed that fraud because this was a fellow that shot at me and my wife, shot and killed my dog, and they charged me with assaulting him for telling him to stop.
Is that
And
the January 15, 2004? Is that what you're saying?
Yes, ma'am. That was, the grand jury
Okay.
dismissed that. That's illegal for them to even have that on the record. It was supposed to have been expunged because the grand jury came back with a not true bill.
Okay.
That's-
Anything else in this document that you object to?
I mean, when I was, a bumper violation that was dismissed, everything else has been dismissed. This worthless check is a fraud. The dogs running at large was a fraud. They dismissed it, and the aggravated assault was dismissed by the grand jury because I assaulted no one. I was assaulted, actually. My dog was shot and killed by a man. It was
All
just
right.
a nut. And, of course, that's what they do in Tipton. That's evidence right there of the abuse of power that these people are committing every day.
You'll see in the final column, the pretrial services office is not stating that you were convicted of all of these things. They are listing what appears in your criminal history.
Well, the problem I have is that when the grand jury comes back with a not true bill, they're supposed to strike it from the record completely. It's not supposed to show up anywhere, at least by the statutes in Tennessee. I don't know about Nebraska.
All right. Anything else on this document?
I don't know about this. Says a warrant for failure to appear 2 counts in 2009. I don't know what that's talking about.
Okay.
I've never been charged with failure to appear or gone to trial on a failure to appear other than this last time, and that's because I didn't have a notice to appear. Let's see. Okay, and the possession of a weapons charge, which stems from this whole thing from 2014, it says right here it's been dismissed.
Correct. So you don't object to the fact that, I mean, it's saying the counts were dismissed. That's true information, correct?
Right. I'm looking for a felony conviction here that there's not one, and I'm supposed to have been convicted of a felony to be here today, I believe, is the issue.
We're not
Okay, here.
deciding that today.
It's not even on here from 2009. There's no conviction for a felony in 2009.
Okay.
So
Anything else you're objecting to on this document?
Well, if this is correct, then there's no listing of any felony convictions from the time prior to the arrest of this charge, which was, or the indictment, which was April the 19th.
And we're not taking up that particular type of motion today. Today's motion.
But on it, Your Honor, on its face, if they don't have a charge of felony to prove that's the basis for the charge, I move to dismiss the charge and release me immediately.
The pretrial services report is not the government's evidence. The pretrial services report is the court's. And this is what the court found.
And I agree. That's what's happened is, Your Honor, and you have a copy of the reasons for judgment. The state of Tennessee, the governor of Nashville, may have exonerated me based on that reasons for judgment. That might be why it's not there. Because I recall talking to a friend of mine that was a deputy in Memphis, Shelby County, who pulled up my record back in December of last year, and he said that, quote, there's nothing there on you anymore. It's all gone. So maybe the governor signed your exoneration.
Okay. I have stricken the matters that you have requested that I strike. I'm printing a version with the stricken matters on it. We will make that an exhibit in this case. Other than that, the pretrial, with those strikeouts, the pretrial services report is received. Any additional evidence by the government?
Oh,
All right. Any evidence by the defendant?
this one here, it says May 16th, 2015, warrant served, further status disposition not served, convicted felon possession of firearm. That's false. There was no anything with possession of a weapon. That's the day I got out of prison.
All right. I've received the pretrial services report with the strikeouts that you requested, or with the modifications that you requested. I'm not going to be taking up any motion to dismiss today.
Well, ma'am,
We'll mark that as Court's Exhibit Number 1. Any evidence by you on the issue of the detention?
Me?
Yes.
Yeah, this thing is totally wrong. Yes, ma'am. If I can find it here, one moment. And Your Honor had informed me that this court follows the United States Supreme Court decisions as well as the United States Code and the Constitution for the United States, correct?
Correct.
Okay.
We are bound by the law of the United States.
Thank you, ma'am. Okay. The United States being a signatory to the Vienna Convention on Diplomatic Relations, it's an undisputed fact that I am the ambassador of the Chilcotin Indian Nation. And via the Montevideo Convention, my status as a diplomat need not be recognized by the United States in order for this court to be bound to the treaty that the United States of America is a signatory to, which states that they are bound to those treaties, and under Article 3, the political existence of a state is independent of recognition by other states. Even before recognition, the state has the right to defend its integrity and independence, to provide for its conservation and prosperity, and consequently to organize itself as it sees fit, to legislate upon the interest, administer its services, and to define the jurisdiction and competence of its courts. They have done such as that. They have created their own international court. It is recognized by The Hague in Switzerland, Netherlands. I've never been there, so I lose track of the location of these courts. That is the Netherlands. The existence of these rights has no other limitation than the exercise of the rights of other states according to international law. In Article 4, states are juridically equal, enjoying the same rights and have equal capacity in their exercise. The rights of each one do not depend upon the power to which it possesses to assure its exercise, but upon the simple fact of its existence as a person under international law. Article 5, the fundamental rights of states are not susceptible to being affected in any manner whatsoever.
Okay, Mr. Parsons, let me ask you something. Do you have any evidence to oppose the government's motion that you be detained?
Yes, ma'am. The fact is that as an ambassador of another nation under the Vienna Convention on Diplomatic Relations, which the United States of America is a signatory to, Article 29, a person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on his person, freedom, or dignity. And Article 31, the diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. He shall also enjoy immunity from its civil and administrative jurisdiction. That clearly states that the United States of America recognizes the necessity of protecting the integrity of ambassadors from foreign nations as well as the United States of America's ambassadors equally, so that everyone can freely move without the fear of their ambassadors being locked up. And that was the intent of such by the United States of America as being a signatory to this. Furthermore, under the United States Code, Chapter 28, Section 1330, it references that all ambassadors are immune from prosecution in this country. Therefore, that renders this whole matter moot, whereas the United States can't have standing in a claim for which they've already waived their right to standing via these treaties. On my first notice of this indictment 2 days ago, December 18, 2017, the indictment was filed in April of 2017, some 8 months ago, have expired. And bringing me before this arraignment violates the court's own rules requiring that we be brought up immediately if incarcerated. Now, though Tennessee had me there, the state of Nebraska had me for well over 3 months. March 22nd, I believe, is when I was transported. And it's interesting that the court in Beaver City, Nebraska had a pending extradition hearing, and that somehow or another Tennessee was allowed to come up here to Nebraska, kidnap me from a prison without the proper credentials, because the court's jurisdiction still stood at that time that they had the right to do a extradition hearing and determine whether I was to be extradited, because I was fighting extradition. I was trying to go back to the Chilcotin Nation for a business meeting relating to my position as an ambassador, assisting in the negotiations for the Chilcotin Nation's timber deal with a company in Tennessee and their timber with an international buyer for their benefits of developing that resource. My inquiry into the existence of a bond for this claim against me by the United States of America Corporation, I'd asked, was there a bond? I wasn't referring to a bond for my release. I was asking for a bond against the complaint. And I'd ask again, is there an acceptance bond or a bid bond presented in the court record in this matter?
There is not, and there is no requirement that there must be under U.S. law.
Is this considered a tort, or is it considered a commercial crime? I wasn't really clear on that.
It makes no difference. It's a federal crime.
Is it a tort, though, or is it a commercial crime?
If it went into a civil case, it would be a tort. This is not a civil case. It's a criminal case.
Right. As I understand it, that there has to be a contract if it's a crime under statutes, which are corporate policy. They're not law. They're under color of law.
That's a misunderstanding of federal law.
The federal law stipulates it's a corporate policy.
You are incorrect.
The other issue was that this indictment has been altered, which I believe by the rules it makes it void, because this indictment can't be altered from its original once whoever's been, their name's been obliterated as a foreperson signs it. It can't be altered, and there's no way to know whether or not they meant to say February or January. And I presume this is the government's attorney's initials up there.
The indictment on its face, and I can view it right from the court here, is perfectly acceptable.
Well, the concern I've got also is that the indictment does not state a cause by which relief can be granted. It pertains to, and it says twice, international commerce. But under the United States Constitution, Article 1, Section 8, it says, it only grants Congress the power to regulate commerce with foreign nations, among states and Indian tribes, not the people or between tribes.
And your point?
The United States of America doesn't have standing because they don't have authority over interstate commerce relating to we the people or between tribes.
You are incorrect. You are wrong on the law.
And what law is that? I've looked it up. The Constitution is the foundation of the law. You can't pass a statute that circumvents the Constitution. Or is the Constitution no longer the supreme law of the land?
You are wrong on the law. I'm not here to answer your questions or give you legal advice.
I'm not asking for legal advice. I'm asking for a decision from the bench. Are you recognizing the Constitution is subordinate to a statute?
No. What I am saying is that we are not here at this time. This hearing is not about whether the indictment is valid, whether there is a basis for dismissal. What we are here about is your detention. Do you have any evidence?
And that's what this is about. The detention is I'm only detained because of this sheet of paper, which has said it's to be an indictment for interstate commerce, which the Constitution says they don't have a right to regulate me at any point.
That is your position on the law. You are incorrect. Any additional evidence besides legal argument?
Yes, ma'am. The Constitution for the United States is the evidence. In Article 3, Section 2, all cases affecting ambassadors, the Supreme Court shall have original jurisdiction. in Article 6, all treaties made under the authority of the United States shall be the supreme law of the land, and the judges shall be bound thereto and shall be bound by oath to support the Constitution of America.
And that is what I'm doing.
If you are
I'm
not,
giving you an opportunity to give me evidence to support your claim that you should not be detained.
I just did. I think I clearly showed that it's undisputed that I'm the ambassador of the Chilcotin Nation. The Montevideo Convention clearly articulates United States of America. Would you like this, ma'am, as an exhibit? I've got a copy of the Munich Convention.
I think I have several in front of me that indicate that you are of that position with that nation, yes.
Yes, ma'am, and it's undisputed, and the United States of America signed on to these conventions for the benefit of the ambassadors of this government's interests, so that their ambassadors can go abroad safely and return safely, and that's what we want. We want to have the ability to have peaceful relations so that our spokespersons can go forward and develop these relations between other nations. That's what it's all about.
I am taking judicial notice of the Constitution. I'm taking the judicial notice of federal criminal law. I'm taking judicial notice of your arguments. I reject your arguments as to the meaning of the law and how that law applies to the issue of detention. Anything else?
Well, it has to do with the Vienna Convention that says it's illegal to detain me.
I will take judicial notice of the Vienna Convention. Anything else?
Yes, the fact that even the Second Amendment in the Constitution says the right of the people, and I'm one of the people.
And that's to bear arms. The Second Amendment is to bear arms.
Yes,
Are you
ma'am.
saying that, okay,
I'm saying that it's accusing me of bearing arms as somehow a crime when the Constitution, you can't pass a law circumventing the Constitution. That's exactly what the statute does. And I would say that given the fact that the
you're again
Constitution...
arguing a motion to dismiss? That is not what we are here for today. We are here on the issue of detention.
A motion to dismiss can be heard at any time. It's valid, and right now I believe it's as valid as it's going to get. And you're in a position to dismiss this matter right now and release me.
No,
You have that authority.
I will not do it.
Well, then you're circumventing your oath of office.
I signed the criminal complaint in this case. I know what this case is about. There's probable cause to believe that you committed a federal crime. Now, the next question
There was
is
no
there a
preliminary hearing on this
reason?
matter. You're prejudiced, Your Honor, on this matter, because if you signed the preliminary hearing probable cause, you shouldn't even be hearing this matter. That makes you prejudicial because you've already made a determination on your own, and you're not going to go against your own determination, obviously.
Your motion to recuse is denied.
There is an Amendment 8, excessive bail shall not be required. There's no victim in this case. We're talking about somebody accusing me of traveling across the country with something that I know nothing about, that nobody can identify that I have anything connected with it. And they say that they didn't get into this airplane until 3.5 months later. This is interesting that in America, where we're supposed to be free until proven guilty, I would say that this court has enough evidence to not only dismiss this case, but certainly enough to order my immediate release. And given the fact that this court actually has the authority to reference this evidence before them to the state of Tennessee, that an insane notion that somebody can be sentenced to prison for 3 years for failure to appear when they were never given a lawful notice to appear in court is insane. And this country can do a lot better. The last thing I would mention is that under the necessity of me being here is that I'm brought here against my will. I was thrown to the floor 2 days ago when I was brought in here because this is against my will. I don't consent to this. My giving you information in no way confers jurisdiction upon this court because I don't know the form of court. I've asked. You have not answered it directly. I don't know what rules apply. I have not been represented or provided proper legal counsel at any point. I have only spoken to Mr. Vanderslip for a total of 4 minutes, moments before being brought here on Monday, and then today we talked about many things, but for the most part, about him wishing to withdraw from the case simply because various reasons he is not interested in the case. And I certainly believe that I would much rather have legal counsel as the Constitution requires and not someone who's possibly being pressured by the court to maybe not give as good an assistance as one might otherwise. But I certainly don't consent to some notion of a sidebar armchair counsel, which I'm not an attorney. I am not a lawyer, and I have
if you'll listen for a moment, I've already advised you. I interpreted the other day when I said you have not requested counsel. You responded to that question by saying, I demand all my rights. I interpreted that to mean that you wanted counsel. Today, I was advised by Mr. Vanderslice after I appointed him that you would not permit him to enter an appearance in this case if that were to be interpreted as that you were conceding to the jurisdiction of this court. Mr. Vanderslice wanted to withdraw. I granted his motion to withdraw and advised you that if you want appointed counsel, you have to, appointed at no cost to you, you have to complete a financial affidavit, and after you do so, I will look at it. I will assume that if you complete the financial affidavit, that you are thereby requesting appointed counsel. If you do not complete that financial affidavit, and my courtroom deputy will give you a blank copy of that after we are done, I will assume that you are not asking for free counsel. That does not mean that you cannot hire counsel on your of your own from wherever you want to hire them. It is simply saying that I cannot appoint you counsel unless you either ask for it or I can imply that you want it because you filled out an affidavit. That is what I'm trying to tell you. Right now, Mr. Vanderslice is seated with you as standby counsel because you would not let him enter an appearance in this case, because you said that that would be interpreted as acceding to the jurisdiction of this court. That is where we are. You now have been told, as clearly as I can say, what the rules are on getting counsel. You'll get the affidavit that you can complete if you want me to appoint someone to represent you. But you're going to have to allow that person to enter an appearance in this court. If you do not let them enter an appearance in this court, then they can't represent you. That is the rules of our court.
I'm not looking for representation. I'm looking for legal counsel.
Well, that's the same thing.
No, ma'am, it is not. It's
All
totally
right.
different. But what I want to make a point of, Your Honor, is that given the fact I've been locked up in a jail cell for almost a year now pertaining to an arrest warrant that the gentleman mentioned earlier, and that's what I was looking for, because I've never been given this arrest warrant to know the cause and nature of that original arrest. I would love to see the original arrest warrant. I've never been provided. I was arrested without a warrant.
You have a copy of the indictment in front of you.
That's not the arrest warrant. I need the arrest warrant. You can't start an indictment without a complaint. You have to have a complaint. And I've not been shown do we have an affidavit of complaint on file?
No, because I was incorrect before. I did not look at this on a criminal complaint. I looked on it on another matter. There wasn't a criminal complaint, and there need not be a criminal complaint in federal court. It can begin with a grand jury indictment. In this case, evidence was presented to a grand jury, and it began as a grand jury indictment. Am I correct on that, Mr. Sharp?
You are, Your Honor.
Thank you.
And
you do have a copy of the indictment in front of you.
Does the grand jury in Nebraska's federal court system not require a signed affidavit by anyone giving testimony?
It receives testimony live. There's no affidavits.
No documentation. So there's no. Do you record these people testifying? Because I'm going to challenge this indictment because I don't know who's making this indictment. I don't believe it's valid, and I would request this court provide me a transcript of that.
I am trying very hard to give you all of the due process you're entitled to. but you will not listen. This hearing is about whether you should be detained. It is not to challenge the indictment itself. That is a whole different matter. Based upon the evidence that is presented in front of me, I do find that you are a risk of flight and a risk of danger to the community if you are released.
Objection, Your Honor. There's not any evidence before this court that I'm a danger to anyone or a flight risk. I've appeared in court every time I've been ordered to be in court, without exception, and I've never harmed anybody in my life. And there's no facts presented to this court about anything.
You may appeal my decision if you wish. That is my decision. You will get a written copy of my order explaining that decision. And, of course, you may appeal it to the district judge who is assigned to this case, which is Judge Gerard. That brings us to the motion to compel at this time. Mr. Sharp?
Your Honor, the United States calls Aaron Crooks to the stand.
All right. Aaron?
Please state your full name for the record, spelling your last name.
Aaron Crooks, Crooks.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
Who do you work for, sir?
The U.S. Marshal Service.
What's your occupation?
I'm a Deputy U.S. Marshal.
How long have you been so employed?
7.5 years.
What do your duties consist of in that position?
We work... we're the enforcement hand of the judiciary.
Your Honor, I object.
Do you also
I'm sorry. Your Honor, I must object. There's a page on here that I was not given an opportunity to review before you proceeded on, and you kind of caught me off guard there. This back page on this thing, it's saying that I have a criminal association.
I have no idea what you're talking about. I have ruled. We are moving on to the next topic.
But I've been denied the right to review the information prior to your rule. You got me off track there talking about the other things. I was given a basis for my release because the court lacks jurisdiction, and you didn't give me an opportunity to review this. The last page is making statements where there's no basis for the statements.
Are you talking about page 5 of the pretrial services report?
Yes, ma'am.
Those are the opinions of pretrial services. I do not
Based on what?
I do not take those opinions into
I would call the pretrial services to the stand to get testimony in this matter because I've not been heard. This matter is news to me. I just saw it. I didn't see it before, and I would challenge it point by point because none of this is true. I don't have a violent history. I don't have any criminal association. This is ridiculous. There is no pattern of criminal active behavior. I've worked since I was 14 every day of my life, have a wife and a farm, and don't jeopardize any of that. Because I present to people the necessity of standing up for the Constitution, if the Constitution is a detriment and a danger to this government, then that's not my fault. It's the government's fault for being rogue. But I don't see why I should not have an opportunity to challenge this where
it's only valid to challenge it if I considered it.
You considered
I don't
it.
consider the pretrial services opinion.
You made the statement that I'm a flight risk and a danger to...
That was my independent decision.
Based on what?
I will put it in my written order. I will not go into it any further right now. We are late in the day. I will put it in my written order. You are entitled to a written order under the Bail Reform Act, and you will receive a written order. At this point in time, we are moving on to the next hearing.
Can I then, for the record, then assume that you did not consider page 5 as relevant at all in your decision?
I did not consider page 5 as relevant at all in my decision.
And is there anything outside of what's been presented in this that you considered other than testimony here today to make your decision?
Other than the testimony that we received today, no.
Have you been in contact with any other judicial officers regarding this matter?
No.
Judge Walker of Tennessee?
I have no idea who he is. All right.
Mike Donovan, the District Attorney of Tennessee?
I've never talked to anybody in Tennessee about this case. I have no idea. I don't know who those people are. All right, Mr. Sharp, you may proceed.
Do your duties also involve transporting prisoners and taking them from court and to detention facilities and vice versa?
Yes, they do.
Do you know an individual by the name of Michael Wayne Parsons?
Yes, I do.
How is it you know him?
Mr. Parsons was brought into the Marshal Service holding for court on, I believe, the 18th of December.
Are you talking about Marshals Service custody up here in the state of Nebraska?
He was brought up to our facility for his first court appearance here, yes.
Okay. Is it correct that he was actually picked up on a writ from the state of Tennessee?
Yes, he was.
And is it also your understanding that he is serving a state sentence down there?
I believe so, yes.
Now, does the United States Marshal Service have any policy that has been issued that requires medical testing of people who are being detained?
Yes, they do.
Do you have exhibit number 1 in front of you?
I do.
Can you identify what exhibit number 1 is?
This is the U.S. Marshal Service Policy 9.6, detailing prisoner airborne pathogen control.
Okay, and have you reviewed this policy before?
I have.
And is this, in fact, the current policy that's in effect for the United States Marshal Service?
Yes, it is.
Do you know where this was obtained from?
This was obtained off the U.S. Marshal Service intranet and basically our policy manuals online.
Does this particular policy discuss tuberculosis testing?
Yes, it does.
And does it also discuss procedures on how to administer such tests and what to do if a detainee refuses to submit to such testing?
Yes, it does.
Your Honor, I would offer Exhibit 1 at this time.
Any objection?
Objection.
And the basis of the objection?
I don't have the exhibit.
It's right here.
This does not, I've scanned through
I
this.
need a basis for your objection.
It doesn't incorporate into it the United States Supreme Court decision regarding the Title 42, 2000 BB, the Religious Freedoms Restoration Act, which clearly exempts people of religious convictions, Native Americans specifically, but it incorporates other religions too, whereby it specifies that where there is a rule of general applicability, meaning that it applies across the board, there's an exception when it refers to religious freedoms. And in the case of TB test or flu shots or anything else, I am exempted from taking those because it is against my religion. And the fact is that the United States Supreme Court recognizes that I have a right to my freedom of religion, and I do not do the TB shots. I've never done any of these things simply because the manufacturer stipulates they don't guarantee the safety or effectiveness, and I don't take chances with my body. I don't stick needles into my body. I don't do Western medicine. I'm naturopathic, as you have as an exhibit that I am a ordained minister in the Native American Church in the Menha, which is strictly forbids the use of chemicals, drugs, Western medicine, any of that. We utilize natural remedies, which is the basis of all medicine. And the Supreme Court went on to rule and talk about this, and that they said the penal facility's interest in maintaining a safe environment goes to the extent that they
Sir,
can
what is
isolate
your
you.
objection?
Ma'am?
What is your objection?
This does not include all the information relating to the cause of TB.
It may be incomplete in your opinion, but it is received. Mr. Sharp, you may proceed.
Does the policy, just for purposes of helping people navigate this document, if I could refer you to the first page, subsection D2, does it indicate who it is that is to administer any such tuberculosis testing?
Yes, it does.
Specifically, who is to do that?
A healthcare professional.
Does it indicate when it is the person is supposed to be tested once they come into U.S. Marshals policy?
Yes, it does.
And when is that in relation to when they come into Marshals custody?
As soon as possible, but no later than 14 days.
And then directing your attention to page 6 of the document, specifically section 10B1, does it indicate how the test is administered?
Yes.
Specifically how?
It says TST, PPD, or Mantoux tests should be administered every prisoner upon admission.
In fact, does it indicate that that is done by an injection under the skin?
Yes.
Is it correct that sometimes detainees or prisoners refuse to submit to a TB test of that type?
Yes.
Does the policy also set forth how that is supposed to be handled?
It does in section E5.
Is that start on page 3 of the document?
Yes, it does.
And just looking at, going over on to page 4, is it correct that there is an alternative that is available to the prisoner if they don't want the injection?
Yes, there is.
Specifically under C, what is the alternative that is offered to the prisoner?
A chest X-ray. A chest X-ray.
Now, you've indicated that you know Mr. Parsons, correct?
Yes,
Have you reviewed his case file?
I have.
Objection.
Overruled.
Do you, from your review of your case file, do you know whether or not he has been approached about submitting to a tuberculosis test since he came into U.S. Marshal's custody?
He was asked on the 13th of December.
Okay, by whom?
The nurse or the medical staff at the Saline County Jail.
Did he agree to submit to that testing?
He did not.
Does his file indicate he has ever undergone any testing at all?
It shows that he has not.
Where is he currently being held?
In Saline County Jail.
Okay, that's county jail, is that right?
Yes, it is.
Is that a contracted facility for the United States Marshal Service?
Yes, it is.
Do they nonetheless follow the federal standards in terms of tuberculosis testing?
Yes, they do.
He has not been tested for tuberculosis. Has that resulted in any alterations being done in terms of where he's being held at that facility?
He's not in general population. He is in a singular cell, I believe, in segregation.
And is that due to his refusal to submit to TB testing?
Yes.
Is it also correct that he had refused to submit to TB testing when he was first taken into custody in the state of Tennessee?
I believe so, yes.
Was any special dispensation made to get him up here as a result of his refusal?
Yes, it was.
What was that?
He was transported. Normally, he would have been transported via JPATS, probably flown up here. He was transported by van up here. And I don't believe he had any contact with any other prisoners.
I have no other questions, Your Honor.
Cross-examination.
When was I taken into custody by the U.S. Marshal Service?
Where?
When?
What
What day? When was I first taken into the custody of the U.S. Marshal Service?
I am unaware of that exact date. Are you talking here in Nebraska?
No, sir.
Transfer of custody to the District of
In
Nebraska?
Tennessee.
I do not know what day. I would have to look back at the computer.
September 27th,
I
22nd?
do not know.
September 22nd is the date.
Okay.
Are you aware that I was taken to the West Tennessee Detention Facility and held there since September 22nd until December the 13th?
I know that you were held in Tennessee. I don't know where the facility was.
And that is a U.S. Marshal Service contracted CCA Core Civic facility, West Tennessee Detention Facility.
I don't know if that is or not.
Do you know if the U.S. Marshal Service uses CCA Core Civic facilities for holding facilities for detainees?
We do.
Thank you. And you have no record of the time that I was there housed in and amongst other people that after 10 days they realized that I don't have TB and I was allowed to go throughout the facility for over 2.5, almost 3 months.
I have no record of that.
For 3 months I was in the system with no TB test because they recognized that I'm not symptomatic and they recognized my religious convictions.
I don't
Then
have
are you aware that I was moved from there to Leavenworth, Kansas?
No.
How did I get from Tennessee to here?
I don't know the exact route you took. I don't
Okay.
know who was involved in the transport. I just know it wasn't us.
Okay. If I'm transported from Memphis or Mason, Tennessee, actually, to Leavenworth, Kansas, with drivers and passengers and so forth, and there I'm in a room and I go out in the vicinity just as everyone else does, being housed in segregation, one-man room, with other men in one-man room. They all get out and go take showers. I take a shower when everybody else is taking a shower, go the various things that they have. As we are right now, proximity, Mr. Vanderslip is right here beside me. He seems quite calm about being in the vicinity of someone who hasn't had this TB test. I would think that if he was concerned, that he would certainly probably not be so close to me.
Your Honor, I object to the form of the question not being a question.
Sustained.
Are you concerned about me being TB at this point? I mean, you brought me in here the other day at close quarters, correct?
I bring a lot of people in. If you have tuberculosis, I get tested every year for tuberculosis. So it's very likely if you have it, then I'm going to catch it.
Are you familiar with the religious exemption of TB?
No.
Are you familiar that TB has symptoms of fever and persistent coughing and such that make it readily apparent when people are symptomatic, that's when they're contagious? That people who have TB don't necessarily test positive, nor do they demonstrate symptoms, nor are they symptomatic. Are you aware of that?
You didn't make sense to me there.
There are people that have TB
Okay.
that actually have no symptoms.
Okay.
And when they're tested for TB, it won't show up. But they are a carrier because the test is not effective, nor is it safe, according to the manufacturer. I'm just going by the manufacturer. Have you ever studied the insert to see who the manufacturer farms out the manufacturing of this to when they run short?
Objection, relevance.
Well, the relevance is that there's no checks and balances in the consistency of the pharmaceutical company that manufactures it, and because of that, they're utilizing adjuvants such as squalene. Are you familiar with squalene?
No.
The objection is sustained.
The reason is that you need to know for your own consideration that squalene causes Guillain-Barré syndrome, which is paralysis. And if they don't have that, they put thimerosine in it, which is mercury, which causes brain damage and early onset Parkinson's and other types of neurological problems, as well as Alzheimer's. Those are the side effects you can get from taking an unknown and unsafe testing chemical known as the TB test. And I do research.
Your Honor, I'm going to object
and
again to the defendant testifying.
the fact is
question
Sustained.
questions.
Ask a question.
The fact is, you don't really know me at all, do you?
I just know you as a prisoner in our cell block.
But you don't know me. You just escorted me in the other day, correct?
Correct.
Okay. Actually, yanked me in and threw me to the ground. Is that correct?
I forced you into the courtroom, yes.
Okay. And given the fact that if I move from Tennessee with drivers and passengers to Leavenworth, here again I'm around inmates and they realize I'm not symptomatic and they've done their research and they realize that, okay, he's right.
Sir, you must ask a question. You are not
Are you
permitted to
familiar with-
simply testify.
Okay. Are you familiar with Title 42, Section 2000 BB, the Religious Freedoms Restoration Act?
No.
Therein, the Supreme Court ruled that under rules of...
Objection to the defendant testifying. The witnesses said he doesn't know that anything about that statute.
Sustained.
If he is testifying as the expert for the state regarding this,
He isn't.
he may have heard about it.
He isn't testifying as an expert. He's simply stating that this is the policy of the facility.
You have lots of policies that you go by. Have you ever come across a policy where the Supreme Court ruled that your policy is illegal and you stopped that policy?
No.
You've never stopped a policy.
That's not what you asked me.
Have you ever had a policy that you had that was stopped for some unknown reason?
We have updates to policy all the time.
All the time. And the reason they're updated is because laws change.
Laws do change.
That's right. The Supreme Court makes decisions all the time which affect your policies. And in this case, when was this published? I see there's a date here at the bottom. It's effective 2010. Okay. The Religious Freedoms Restoration Act was responded to again in 2012 by the Supreme Court, further enforcing the fact that people of the Religious Freedom Restoration Act was,
And I'm going to object to this as not being a question posed to the witness.
I'm giving the
Sustained.
gentleman some background. He may have a recollection of hearing about it. 2012, it was
Well, you're well beyond the scope of the direct examination at this point, because all he testified about on direct examination was that this is the policy of the Marshal Service, asking him about how it fits with current U.S. Supreme Court law. He is not a witness as to that issue, and he did not testify as to that issue on direct.
So you would say that you're not qualified to respond to what the Supreme Court's position is regarding the forcing of a TB shot on someone whose religious convictions are opposed to that?
No.
Okay. Nothing more.
All right, you may step down. Oh, wait, did you have any redirect? I'm
I was
sorry.
just going to say nothing further, Your Honor.
Okay, you may step down.
I have nothing further, Your Honor.
All right. Any evidence, sir?
Your Honor, the court shall take judicial notice that under the Title 42, Section 2000 BB, the Religious Freedoms Restoration Act, this was stemming from a lawsuit with the Native Americans of the United States regarding abuses against the indigenous peoples for well over a century. And the United States Supreme Court and the World Court came to a settlement agreement that they would recognize the religious freedoms of all Native Americans worldwide, allowing them to partake in their customs and traditions, including natural medicine. You may have remembered at that time when this was passed that all of a sudden there became a bumper crop of peyote plants being harvested and manufactured and sold, and a lot of people were being prosecuted. The Vigueros case in 2011 in New Mexico, where they were all lily white people, as the Supreme Court, or Alberto Gonzalez said, they're all lily white people. They're down there doing ayahuasca, getting tripped out on ayahuasca. And Justice John Roberts said, no blood quantum required, because they're practicing a Native American tradition. Though they may not have one drop of blood of Native American descent in them, it's their right to practice their religion as they see fit, and they were case dismissed of a Schedule I drug. Case in point is that there is support by the Supreme Court time and time again for the Religious Freedoms Restoration Act pertaining to indigenous peoples and practitioners of indigenous religions to practice their religion. I have never had a TB test. I do not consent to it. This is my body. You have the credentials that I am a ordained minister in the Native American Church of the Menha. Anything forced upon my body is my temple through which I do my ministry. Forcing any unknown substance into my body against my will is considered cultural genocide by not only the Supreme Court, but the World Court in The Hague.
All right.
I object to being forced to take anything that is unnecessary, and I have demonstrated I am not symptomatic. All of these facilities have no problem with me. Right now where I'm housed, I'm right there at the guard station. They sit there and talk to me all day long. They're not the least bit concerned, even the nurse.
All
They've
right.
gone to my website. They know this is a railroading. They don't like it either. I
All
would
right.
move that this court allow me to preserve my body because I don't consent to it, and it's unnecessary, and it deprives me of my God-given right to preserve my body through which I do my ministry.
All right, I will take judicial notice of your comments. Anything further from the defendant?
I think the Supreme Court's decisions has spoken clearly that they recognize the rights of all people regarding their religious freedoms pertaining to forced inoculations. Even the nurses who've argued against being forced to take flu vaccinations prevailed in the Supreme Court. And I'm just one man standing before you today asking that you recognize my rights as a human being and an American, and as a Native American, respect those rights and customs that I have practiced my entire life and not force upon me, because I will not consent. And they will have to hold me down, and they will hurt me. And if you wish to order additional harm against me, that is something that I can't prevent. But they will have to do this by force. And I am in very poor health. I have had 3 broken ribs that are still healing. The doctors notice that you've got a test of that. I'm not a violent person, but I will protect myself from harm. I do not wish to be forced medicated with anything that is against my will. It is inhuman.
All right.
I ask the courtesy of this court to respect my religious freedoms.
Mr. Sharp, anything you'd like to say?
In terms of argument, Your Honor?
Yeah, I believe we're on argument now.
Yes, Your Honor. The court had identified at the last hearing Turner versus Safely as being the case that would likely govern the court's analysis of this regulation, and I agree. As I read Turner versus Safely, it appears to me that there are 4 factors that the court is to look at in deciding whether or not an institutional regulation can be enforced over objection. First, there has to be a valid rational connection between the regulation and a legitimate government interest put forward to justify it. Exhibit 1 is the U.S. Marshal's policy, and it explicitly says that it is aimed at screening for tuberculosis to prevent the spread of disease. That's referenced on the first page. The Eighth Circuit Court of Appeals has repeatedly held that TB testing is rationally connected to a legitimate government interest. The court has held that in Lee versus Armentrout, and in the other Eighth Circuit case, DeGidio versus Pung. I think I've supplied both of those cites to the court previously. There are also 2 other court decisions that the court had noted, Darby versus Schetzel and Benjamin v. Hobbs, both of which hold that testing for TB is it's rationally connected to a legitimate government interest. The second factor under Turner and Safely is whether or not it's a reasonable restriction and whether or not there are alternative means available to the inmate to allow him or her to protect their interests. In this case, Mr. Parsons obviously does not want an injection. The policy actually contemplates somebody that might object to an injection and allows them to have a chest x-ray in its place. The third factor has to do with whether or not an accommodation of the detainees' inmates' interests would have an impact on guards, inmates, and others. And obviously, I think that's self-evident. If somebody, in fact, is carrying tuberculosis, we are risking the spread of the disease to others. And then the last factor has to do whether or not there's any other alternatives. Well, the only alternative, if you don't want to undergo an injection or to have a chest x-ray, is no testing at all. And that is not a reasonable alternative when you're dealing in a setting where there are all kinds of people crowded together. That's just running the risk of a contagion spreading. I do have one case I want to cite to the court in relation to Mr. Parsons' objections on religious grounds under the Religious Freedom Restoration Act, Title 42, United States Code, Section 2000 BB. I would direct the court's attention to United States versus Myers, 95 F. 3rd 1475, 95 F. 3rd 1475. It's a 10th Circuit case from 1996 in which a gentleman who was the founder of the Church of Marijuana was arguing that he was commanded by his religion to use marijuana. And the 10th Circuit laid out what the burden is on the person that's asserting a religious interest. And the court held that the person asserting that religious justification must establish by a preponderance of the evidence 3 threshold requirements to state a prima facie free exercise claim. The governmental action must, 1, substantially burden, 2, a religious belief rather than a philosophy or way of life, 3, which belief is sincerely held by the plaintiff. The government need only accommodate the exercise of actual religious convictions. And I would argue that simply asserting that his religion does not allow him to undergo either an injection or a chest x-ray is insufficient. There's no showing in this record on how requiring him to undergo TB testing would violate the tenets of a true religion. That's all I have.
All right.
May I
Response?
respond? Thank you for citing the Myers case. That's an excellent case. This is actually the case that I use in the Tennessee jail in order to not have to take TB shot. That's why all these facilities haven't forced it upon me, because of the Myers case. So thank you. This is a case where the Coptic Church of Ethiopia, the Church of Pot as somebody refers them to, had a truckload or a barge full of pot come into Boston Harbor, I believe it was. They were arrested. And after it was determined that this is a sacrament of theirs, the judge ordered the pot released, and they went on their way. They were released because it was a deeply held religious conviction. I've articulated to this court, I hope, that I don't do injections. Never have. I'm 56 years old. I think that stands to reason. It's a fairly deeply held religious conviction of mine that I don't do Western medicine, period. I have not, in my adult years, I haven't been to a Western medicine doctor, a friend of mine that I occasionally play golf with 30 years ago. I have a letter from a naturopathic physician. I myself don't have the numbers and designation behind my name, but I too am naturopathic trained exclusively in natural remedies. So if you've got hepatitis, I can tell you the natural way to cure it. This is excellent information because I've cited all of these three standards. I've met all these credentials in my presentation today. And I had forgotten about the Myers case, but it is the landmark case that they establishes. But however, beyond that, the Supreme Court, Justice John Roberts in the Vigettos case, pointed out, and they still rely back on the fact that this is not a life way. This is not a fad. This is a religion. This is part of my religion. And I'm not sure if Your Honor is familiar with many Native American customs and traditions. Friends of mine that are a Seventh-day Adventist, they too practice natural remedies. Consequently, many of them live to be well over 100. As my friend Dr. Joel Wallach says, those people live to be well over 100, and their medical record charts usually find two things: a birth record and a death certificate. Those people that tend to die early tend to have these thick records, and in this country, the CDC's own statistics show that the number one cause of death in this country, if you add interactions with prescription drugs and botched medical procedures, add those two together, that's the number one cause of death. Who attributes to those? Doctors prescribe the drugs and do the medical procedures. Dr. Norm Shealy is a friend of mine, former Surgeon of the Year, voted 4-time Surgeon of the Year, brain surgeon. He is also a Native American Menha, naturopathic. He treats people naturally. Totally has moved away from Western medicine. He cures people of diabetes, type 1 and type 2, with tremendous success. I do not have a problem with being isolated, which I have been, and after 10 days, in the TDOC's system, their policy in the state of Tennessee, the federal system, is that after 10 days, if you're not symptomatic, there you go. I'm not symptomatic. I don't have TB. The fact is TB is extremely rare in this country. It's outside of a few cases coming up from south of the border. There's virtually no TB in this country, like polio. It's a rarity, and they're finding out that polio has other marketing techniques where they've actually put the polio virus back in some of these viruses to get polio back into the environment. They say it was to stimulate people's immunities. By humbug, it was to create a drive for the polio vaccine to generate profits. Just like Bayer Pharmaceuticals putting Factor VIII out in Africa with AIDS virus, and they were sued and they paid out millions, but they made billions. It's all about profits. The TB is no different. A manufacturer that manufactures these makes money off this. It's all about money. I, for one, don't want to be a statistic with paralysis or memory loss, because heaven knows there's too many other things out there causing memory depletion in the environment, in the population. It's a tragedy. The statin drugs, the CDC admits now that they're the number one cause of Alzheimer's. Reduces the cholesterol, which your brain sits in a pool of cholesterol. So I know this stuff. I'm asking you to recognize the Religious Freedoms Restoration Act and the fact that the Myers case, if you review it, excellent case. I've met all of these standards and beyond. I've never done this test. I don't continue to do it now. None of these institutions have had any problems with me. As a matter of fact, they had me coming out of my one-man room and going down and assisting other inmates in West Tennessee that needed help on the computer because they didn't have computer skills and they needed help. And so I assisted many men in that. I spoke at length with the chaplain there about assisting them in religious aspects that a lot of these young men that get in there, they don't have a religious background. And so they might interest in certain areas. And I'm the only guy in the unit that has a background in Native American and other religions of the world. And so I can talk to them on various levels if they had an upbringing in certain types of religions. And that's part of my ministry, is trying to help people where they're at so that they can benefit from the blessings that God has given us. My blessing is my body. I wish to preserve it. Please allow me to continue in my ministry and in my religious beliefs and practices, which is non-invasive medicine. And again, if these people thought I was a detriment, even the nurse said, he doesn't have TB. I don't. I'm not a carrier.
All right. Ms. Bierbauer, may I have the exhibits?
Yeah, approach you.
Yes, you may. The exhibits from the initial hearing.
And ma'am, just to reaffirm, if I may, under the Religious Freedoms Restoration Act, it says where there's a rule of general applicability, and I guess we can all stipulate their policy is a rule of general applicability, meaning it's across the board. In those cases where we have these three criteria met, then the religious conviction is respected and the individual is allowed to practice that religious conviction. Even to the degree that in the prisons in Tennessee where smoking apparatus and matches and such are not allowed, the Native American religions are allowed to do smudging, which is where they burn various sages and various grasses and do a ritual called cleansing and smudging for the purification of the spirit. And this is another Religious Freedoms Restoration Act where there's a rule of general applicability where nobody can have matches, let alone smoking materials. They are provided that for their religious conviction and practice.
All right. I'm going to assume for the purposes of the argument that today that you have demonstrated that taking a TB test, the injectable TB test, is a burden on your free exercise of rights, and that it would be a violation of the Religious Freedom Act. If I were to, even though I assume that, a government may substantially burden that exercise of religion if it demonstrates that the application of the burden to the person is in furtherance of a compelling government interest, and it's the least restrictive means of furthering that compelling government interest. In this particular case, we are dealing with a population of people that are housed in a closed environment. Tuberculosis is a very harsh disease. It is highly contagious and can have far-reaching and devastating effects on people. If it is not aggressively tracked, it can spread from one person to another, particularly in the closed setting of a prison. People inside of a prison are sometimes people who are natural targets for this disease, people who have had HIV, AIDS, those types of things. It is a serious threat. The Eighth Circuit has determined such. They have said that tuberculosis inside of a prison system is something that the prison system is required to ward against and is required to monitor to avoid harm to the rest of the population, including the guards within the prison system. And so when I look at your determination and your convictions on a religious basis, I have to strike a sensible balance between you and what you believe and the competing government interest in this case. In striking that balance, I do find that the balance weighs in favor of the government. You will be required to have a tuberculosis test. It will be up to you to decide whether it is the test that requires an actual pinprick or needle prick, or if it will be an X-ray. But you will be required to do one or the other of those, and that is in furtherance of the government's interest in avoiding the spread of tuberculosis within the prison system. Anything that else we need to take up?
I would like to respond. I don't consent to that, and I wanted to know to the degree, are you going to order this with force to the degree that my bones are broken or death? How far do you want to go with this, Your Honor?
You will be, I am telling the marshals that they are permitted to impose the test. The degree to which it harms you is in part based upon how you respond.
I will fight to the death.
All right.
This is my life, this is my body, and you don't have a right to rule over my body. You don't. You don't have jurisdiction over my body, and that's something you don't have a grasp of, ma'am. Because you have a position as a judge ruling over people that come before you, you do not have the first inkling of the rights of a human being to freedom of religion. You've just demonstrated that. Now,
I
if you
have
want
an
me
understanding
dead,
of the law.
you just
I have
sentenced
made
me-
my ruling, sir, and it is not subject to any further debate.
Well,
We
I
are
need to
in
know
recess.
if you're sentencing this to be up to including death so I can have my... I'm not.
We're on the record.
You're not?
Good-
Please stay seated.
Good afternoon. No, ma'am, I got no advance notice. I don't even know why I'm here, and I would ask for continuance to be given advance notice so that I can prepare, because I have no clue as to why I'm even here.
Okay, we're going to go forward with what we're going to do today, and if as we go through the process, are we on the record?
We are.
Okay. If as we go through the process, something comes up that you're truly not prepared to respond to, then we'll take that up at that time. But I think we can clarify and keep my point for this today, sir, is to try to clean up some issues that you've been presenting to me and that you've been presenting to me, so that we can keep you apprised of your case, keep you informed on how to represent yourself in this matter. And so the whole hearing is for your benefit. I don't think you want it to be continued once you hear what the goal is. All right? We're on the record in case number 4:17-CR3038, United States of America versus Michael Wayne Parsons. Counsel for the government, enter your appearance.
Good afternoon, Your Honor. Jan Sharp appearing on behalf of the United States.
And I see Mr. Parsons is present as well, and Mr. Vandersice is standby counsel for the court.
No, ma'am, I'm Ambassador Michael Parsons. I am not the defendant, as I've asserted before. That is a corporate fiction.
All right.
And I've got a document here I'd like to present the court at this time. Given the fact that I've not been given advance notice of this hearing, I've just been brought in here by force against my will. I object to this hearing, and I would ask for continuance at this time. But at this moment, I want to present to the court a petition that I have served upon the Eighth Circuit Court, given the fact that I have not been served with their ruling for a stay pending the orders of this court, but yet I've been advised verbally that they have potentially denied or dismissed it. I have a petition that has been sent to them as of yesterday that I'd like to present to this court, so this court is fully on notice of that petition before the Eighth Circuit before it proceeds any further.
You can provide that to me, but I want to make sure you understand, sir, that I have already determined, based upon my research, that your appeal to the Eighth Circuit on the issue of tuberculosis testing did not divest this court of jurisdiction under the underlying matter, being the criminal case. And so I'm not divested of jurisdiction. Plus, I am going to give you a copy right now of the order that came from the Eighth Circuit that has determined that your matter is not before them at this point. So
the issue before the Eighth Circuit was not just TB, it was also a motion to dismiss that they were taken up in my petition to them, some 21 pages. I went at lengths about the fraud that's being committed by this court and by Your Honor, who's putting false information into the record and not giving me an opportunity to rebut that information on the record, and therefore this court is committing a fraud upon me in many ways, given the fact that, number one, you appointed Mr. Vanderslice before I was ever brought in here, and he immediately withdrew, not on the second day, but on the first day. And then you immediately appointed him as elbow counsel just so that you could obtain jurisdiction in this matter. That's fraud upon the court. And then in this most recent response, you've changed your position that he was appointed after I was brought into the court, and then he's been in the vicinity of me. But ma'am, with all due respect, this box of Kleenex in front of me has given me more counsel than Mr. Vanderslice. Mr.
Vanderslice, you may approach.
Has done nothing to assist me in this matter. He's not filed a single motion on my behalf. I've never waived my right to legal counsel. I did not ask for an attorney, as you asserted. I asked for legal counsel, which I'm entitled to. I'm entitled to know the true nature and the cause, not the forum, but the form, F-O-R-M, of court. Is this an admiralty court?
And as I've told you now in writing twice, and I've told you verbally, this court has been formed under Article 3 of the United States Constitution. It is the United States Federal Court for the District of Nebraska. I will not repeat that again.
But you're not answering the question, ma'am. The form of the court, is it an admiralty? Are you operating an admiralty law? Is this mercantile?
I can, but that's not what this case is about.
Are you operating admiralty law?
I can, but that's not what this case is about.
Are you in this matter operating admiralty law?
I'm not applying admiralty law in this case.
What form are you operating under? Statute law?
I am done answering your questions, sir, and you are done talking for a moment.
I have a right to know.
You are done talking.
No, ma'am, I'm not done talking. You're going to listen to me. I have a right to know the form of this court. I will not proceed. I do not consent to this matter. You are relieved of duty. I will not proceed any further. You are now served. This is the motion that relieves you from this court. This matter is adjourned. This matter is dismissed. We will not go any further until you disclose the form of court that you're operating under.
Okay. Here is what I convened the hearing for. And we're going to take up those matters. If you choose to participate, sir, you may. If you choose not to, you don't have to. One of your claims is that you have not received the discovery from the government, and I received information back indicating that for whatever reason, the flash drive is not available to you at this point. I'm not going to get into what happened to the flash drive. I don't have to at this point. My real concern is that you have an opportunity to see and read and listen to all of the discovery. And so Mr. Sharp responded to that yesterday, I believe, with a proposal of what to do today at this hearing. Mr. Sharp, tell me what your plan is.
Your Honor, I have brought another copy of the flash drive, which I will present to Mr. Parsons in court, hopefully with the court's approval that this is the proper procedure to follow. Also, one of his complaints in his filing was that there was a copy of the search warrant that was missing page 14. I went back through the discovery that was originally sent to Mr. Vanderslice, and Mr. Parsons is correct. Page 14, the signature page was missing. I have a full set of that search warrant that's contained here that I also intend to give to him. I also have printed out all of the documentary evidence that was on the flash drive in a hard copy, which I intend, again with the court's approval, to give to Mr. Parsons. Now on this flash drive, and I was explaining this to Mr. Parsons before we began today, there are many, many jail calls, perhaps 200 plus, 225 plus. The vast majority of the calls on that on this flash drive have absolutely no relevance to this case whatsoever. In the government's, it's the government's position that there are less than 5 relevant calls or conversations or video recordings that are relevant to anything in this case. I am willing, if it will assist him in conducting a review, to identify by number and date exactly which 3 to 5 conversations the government believes is relevant. And I'm also willing to say that we won't use anything that's not amongst that 3 to 5, whatever I identify, moving forward.
All right. You
Your
may
Honor,
hand that information to Mr. Parsons at this time.
Your Honor, I
Actually,
object.
the flash drive, I'm going to, yeah.
I object because I filed a motion to suppress that evidence, given the fact that Your Honor told the Assistant U.S. Attorney that he had until 14 days following the 18th to serve that upon me directly. You formed him to serve it directly to me because I was not represented by counsel at that time. The 2nd of January came and went. I had not been given it. This court did not advise him to give it to somebody else or anything else. I did not know anything about it, nor did I see any of this until after the 16th of January, well beyond the deadline date. And I have a right to a speedy trial, and I have a right to a suppression of any evidence that the U.S. Attorney had or would have had access to up until the 2nd, because it fell on the 1st, that was a holiday. The 2nd of January was the deadline. He did not meet that deadline. Therefore, he has no right whatsoever, no grounds to submit any evidence beyond that point in this matter. That's why I moved this court to suppress that under your own rules that you sent me. I had followed that, and I ordered, or I petitioned this court to suppress that, and I demand that that be done at this time, because otherwise this court is just working as it appears to have been doing all along on the side of the United States of America, the plaintiff, who, Your Honor, inadvertently someone slipped in my information that clearly you were working for the United States of America and doing research on the TB issue from the very beginning. That's prejudicial. This whole case is prejudicial, and if you're not going to follow your own rules of suppression of evidence and follow my demand of suppression and a speedy trial, then this whole thing is just a kangaroo court. It's a fraud. I think we can do better than that. So I moved at this point to recognize my suppression of evidence motion, that evidence is not valid. It can't be used. Anything that he had up until or could have had access to up until the 2nd of January is void, and it can't be used, and I move that it be suppressed.
Based upon your statements, I assume that you have not received the findings and recommendations that I already put out on that same motion. I mailed them to you on the 7th. It's the 9th, so that makes some sense that you may not have gotten it yet. Mr. Vanderslice, you may approach.
I object. Mr. Vanderslice does not.
He is just operating as my courier. Thank you, Mr. Vanderslice.
That let the record reflect that Mr. Vanderslice is a courier.
He is operating as my courier on that particular issue.
I
And
have
doing
not-
better than a box of Kleenex, I might add. So, now, the next thing is you now have a copy of it that was handed to you, and I'm going to make it of record that was handed to you.
I have
of
not
the
had an
discovery in
opportunity-
this case. Sir,
I have not had an opportunity to review this, ma'am. My hands are shackled. You've got me handcuffed. I can't even get into my own papers.
I'm not talking about the what I just handed you. That's not what this hearing's about. You've received the copy of the government's evidence at this point in time. You've received a new flash drive.
No, ma'am, I have not
sir,
received it at this time. That is not true. I don't have anything. A flash drive that I don't have. I'm in a jail cell with no computer,
and
no access.
If you will be kind enough to be respectful enough of me, I will tell you what my plan is on this. First of all, my understanding is that Saline County is willing to allow you to view and look at the flash drive. Am I correct on that, Mr. Sharp?
Correct, Your Honor.
All right. Secondly, if that poses an additional problem, I have contacted the IT department of the court here. And if it continues to be a problem down in Saline, you can be brought here, stay in the holding cell back here, and the court will provide you with a computer so that you can view it here, if need be. And so I believe that resolves all of the issues that you've brought up about not being given access to look at the flash drive. I hope you will understand that we've never done this before for anyone else because we've never had this issue brought before us before, and what's always been able to be resolved. And so people are figuring out different options, and they're doing it for you. And so if that poses a continued problem down in Saline, you need to let Mr. Vanderslice know or the court know, and we will have you brought to the holding area here, and you can look at your videos and you can listen to your audios sitting in the holding cell here in the courthouse.
This does not address my motion to suppress the evidence that was filed with this court well before the deadline, and this court has not responded to that affirmatively, and I demand that all of this evidence be suppressed because it was not provided to me before the deadline. Today is long past January the 2nd. I do not consent to discovery that could have and should have been given and was ordered by the court to be given directly to me by the U.S. Attorney, and the U.S. Attorney did not comply with that court's order. Therefore, I am entitled to suppression by the rules of the court, and also that I move that be ordered and done today, suppressing that evidence as my petition demanded.
And that motion is denied for the reasons set forth in the findings, recommendation, and order that is currently in front of you in paper. Now, the next matter that I wanted to bring up is that you had requested that this matter be transferred to North Platte. Mr. Sharp was given an opportunity, or has been given an opportunity to respond to that by February 14th. I'm not asking him to respond to that today.
I did file a brief right before I left this morning, and
I have not seen it, so hang on.
And I would also advise the court that I'm going to hand a copy to Mr. Parsons because he has it.
Actually, I just gave him a copy that I had already printed out, Judge.
All right. So just so that you understand, sir, how I would like you to make sure that you get a full opportunity to respond to this.
But see, I'm not. Here, I'm looking at document
I'm not asking you to respond to it right now. What I'm trying to tell you is what I expect of you going forward. I want you to read the brief. I don't want you to, I'm not asking you to argue it right now. I would like you to read the brief now that you have all of the evidence in front of you.
But I don't have, that's not true. I don't have all the evidence. I'm looking at document 55. I don't know where document 54, 53, 52 are. You're just handing me document 51. There's 3 other documents that I don't have. That's the problem with this court is I'm not being served. I don't have legal counsel. The court
and
is
so
ordered.
that is the last question that I was going to bring up today. And for this one, I'm going to have Mr. Sharp leave because I'm going to be asking information about financial stuff. Thank you, Mr. Sharp.
May I provide this document that I've tried to offer the court 3 times now to the court so the court can review it before we proceed?
Currently, unless it is talking about the right to counsel, which is the only matter I have in front of me right now on my agenda, And by the way, this is my court, and so I'm going to create the agenda for today.
So this is not the people's court, this is your personal court.
This is my courtroom right now, and you
Right,
will...
and that's what this addresses, is this is your courtroom. It is not a constitutional court of the people, and that is the problem. You're operating a business, correct?
I'm going to ask you a few questions. You have consistently, sir...
It's a business. You won't answer the question.
This is not a business.
You're concealing the fact that you're operating a business, and I'm not here to engage in business with you. I'm not here to engage in commerce with you. I don't have any contract with you. I don't have a contract with the U.S. Marshal, which is also a corporation, and that's what this notice is about. Unless you've got a contract that you can show me where I have violated the terms of the contract, I don't consent to this. I'm not here to make a contract. I don't consent to these proceedings.
All right, let me ask you a question. Do you want an appointed attorney?
I want you to let me
I want a
alone.
yes or
I want
no
you to
answer.
free me from this hell and let me go about my life, because I don't have a contract with you or the United States of America or the U.S. Marshal Service. You're committing a fraud upon an ambassador of another country, ma'am.
Do you want an appointed attorney? You send me letters saying that you want that, and then you don't send
No,
me the
ma'am,
information.
that is not true. Do you know the difference between an attorney and counsel?
Okay, do you want an attorney?
No. I don't use attorneys because attorneys work for the court. They are not counsel. They are working for the court. Their oath is to the court and not to me. The Constitution of this country does not give me the right to an attorney. It's recognizing my right to legal counsel.
Okay,
You've
do you
denied me
want...
access to legal counsel. You've said that I've got access to a phone to make free phone calls to this gentleman who won't take my calls. He's already withdrawn, and he told me personally, do not call me again last Friday a week ago. Is that correct?
Okay, we're going
comment
to...
on that, Judge.
I will call as a witness Mr. Vanderslice to I want to put him
No,
on
you
the
will not.
stand, and I want him to perjure himself today.
So
We're going to
what-
have a hearing. We're going to have a hearing. Mr. Vanderslice, would you please?
No. You haven't figured out, sir, that I'm the judge.
I don't know what you are because I don't know what kind of form
Okay.
you're operating. You're operating a business here.
All right?
You can call it a judge.
Do you want appointed counsel?
I want you to take this document and read it before you go any further.
All right, let me read it.
Well, I'm shackled and seated, so I'm kind of...
We'll let Jerry be the courier on
That's
behalf of the court at this point. Thank you.
That goes with it.
Did you mail this earlier? Any chance? Did you mail this one to her?
I did, but I don't think y'all got it. It went out yesterday.
Oh, okay.
That's a different one.
Okay.
Yes, ma'am.
Okay.
I would move to subpoena the phone records from the jail to Mr.
If you want me to
Vanderslice.
read this, you have to quit talking. All right. I see that you're not consenting to the proceedings. I see that you believe that this is not a court over which that can exercise jurisdiction over you. And I see that you're demanding a stay of this case at this time. I believe what you're saying is that the matter is before the Eighth Circuit at this time. Is that what you're saying?
I'll be appealing the matter from the Eighth Circuit Court to the U.S. Supreme Court.
All right.
And
And that is certainly, it isn't called, just so you know, it isn't called an appeal. It's called a writ of certiorari.
Actually, no, ma'am, under the Article 3, Section 2, it's not a writ of certiorari, which is a request for permission. It's a demand. I'm demanding rights here. I'm not asking for permission. I'm not a subject citizen. I'm an ambassador. You're a corporation. I'm not. I'm a live man. I'm not a corporation. I'm not a thing. You're treating me like a thing and like property. I'm not a thing. I'm not your property. And I wish you could learn that, because we'd get along a whole lot better. I've harmed nobody. There's no victim in this. You've shown me nowhere where I'm subject to your jurisdiction.
All right. Do you want appointed counsel?
Show me subject jurisdiction first. Show me subject jurisdiction.
Do you want
please.
appointed counsel?
I don't understand what you're talking about, because you're not disclosing that you're an admiralty operation right now.
Do you want counsel appointed to you to represent you in the proceedings at no cost to you?
Until you answer my question, I can't respond, because I don't know how to respond. With all due respect, ma'am, if you will tell me the form of court you're operating, then I'll know how to respond.
I've already told you that.
No, ma'am, you haven't.
All right.
Is it admiralty?
Judge, could I
Administrative?
say something, please?
Absolutely.
All right.
I object. You're not even representing me. You filed a motion that you
I
want
want
to take my calls.
move to withdraw as standby counsel. The ambassador and I and my boss, I've spoken with Mr. Stickman a couple of times about Mr. Parsons, the ambassador, and I've tried to do what I can do to assist him in many different ways, even though he's not satisfied with that. I've tried to answer his questions in ways that I felt were reasonable. I've tried to be available for phone calls, and haven't been available all the time, because, as you know, I was in OCC yesterday. I was in Saline earlier this week. I traveled to visit my clients, and so I have appointments, but I'm in court, so I'm not available at his beck and call. There have been many voicemail messages left on my voicemail. I listened to them all. One day there were 6 of them that go on for anywhere from 5 to 10 minutes many times in a mode where it's hard for me to hear because of whatever phone he's calling from. I visited him once in his isolation cell, and they wheel in what appears to be something that looks like the old type of phone that you would put money into, but I think it plugs into the wall. But it doesn't give me very good reception. But in any event, my point is that at this juncture, Mr. Parsons, Ambassador Parsons, and I are not getting along. And I think you can recognize what I'm saying just from the colloquy that you and I are having. I try to do what I can to answer his questions, but the answers that I have aren't satisfactory to him, or I just simply tell him, I can't answer that question. And that's not satisfactory to him either. I told him right up front that I have represented folks in the past that go through their case in a similar manner to the way that Mr. Parsons is going through his case, which is a very unconventional way, as you well know. I don't think I can be any assistance to him as counsel or as an attorney or as anything that realistically is helpful to him. I can give you an example. Well, that's not completely true. I've tried to send him documents. I've sent him blank subpoenas off of the district court's website. I've sent him his docket entries on his case. I've tried to keep up with the filings and send those to him as I can. There is a lag between the mail that I send and that he gets, from anywhere from a couple of days to maybe as much as a week. Mm-hmm. And so that puts Ambassador Parsons at an extreme disadvantage related to being up to speed like the other folks, like you, like Mr. Sharp, like me, when we get everything electronically immediately. Correct. So, I mean, there is that time lag, but notwithstanding all of that, all of those issues, Mr. Parsons and I are not getting along. Now, I don't know, to be honest, I don't know that he would get along with anybody else that you would appoint to him as counsel or standby counsel, primarily based upon 2 things. Number one, Mr. Parsons has his own ideas about how his case should be conducted, and he is relentless on those ideas. And number 2, I don't think that any lawyer that you would appoint as standby or even as appointed counsel would be able to do the things that Mr. Parsons wants him or her to do in a way that's satisfactory to him. And quite frankly, the second reason is that Mr. Parsons, in essence, is conducting what lawyers and judges would call a pro se representation. He's representing himself. And any noise that he might get from a potted plant or a Kleenex box like me, realistically, is just a point of contention for him to be argumentative, in my opinion. So I'm moving to withdraw and asking leave to withdraw. Because I don't think that appointing anybody else is going to make any difference, and Mr. Parsons is going to continue to act in a pro se manner regardless.
Granted.
Thank you. May I be excused?
Yes, you may.
Thank you. Good luck, Ambassador.
I would like to state for the record that most of what John just said was true, but the other part of it was not true. The other 50% is the fact that he didn't answer my questions that he could have answered, but he chose not to. Simple questions like, are you aware of the Montevideo Convention, the Vienna Convention on Diplomatic Relations? Have you ever done any research into commercial law? Do you know the form of court? Is it admiralty? The form of law that's being operated? Is it mercantile? Is it constitutional, common law, equity, so forth? That determines the rules that apply to the court. He couldn't answer that, wouldn't answer that. He did acknowledge that he was appointed before he ever met me, before day one. His boss even acknowledged, well, that's how the court gets jurisdiction over you, and he laughed because he knew Mr. Vanderslice has a history of withdrawing, immediately withdrawing upon appointment, just so that the court will have jurisdiction, and then the onus is put on the individual to either represent themselves or hire an attorney or submit to a financial disclosure, which is forced contract. In other words, you're forcing somebody to give up a recognized right in order to obtain another right. My right to privacy and confidentiality should not be at jeopardy because I have a right to counsel. Mr. Vanderslice offered me absolutely no counsel the entire time. He did send me these nice expandable folders. He did do that. He did mail me some things, but when I asked him for a complete copy of what's in the trial record, day one, the very first day, he's never done that. The only things that I've gotten from him, I did get a copy of his motion to withdraw from the 8th Circuit Court case after the deadline for filing. Now, he had with them from the 5th of January notice up until the 6th of February. The only thing he filed with them the whole time was a motion to withdraw. Just like today, he hasn't filed anything in this court on my behalf. I've asked him from day one, what do you recommend? What is your suggestion? I asked him. He never offered any suggestions. That's the biggest lie that the man told. He never offered me any advice or counsel on how to proceed in this case. He wouldn't answer my questions. Yes, he is an excellent courier. He's a very, shows up on time, I guess. But in all the times that he came to the jail, he only saw me once for maybe 5 minutes to hand me these folders, and that's it. And contrary to what he said, they don't wheel a phone in. The phone is on the wall. There's no handset. So, yes, the audio is extremely poor. And it costs $4 per 15-minute phone call that this court doesn't understand. I don't have money. I don't have a source of income. I don't have anything to draw from. This is a case where I've been taken away from my family and my life, and I've been locked up now for over a year because of a false charge from the state of Tennessee, and then months after the fact, they claim that an airplane sitting in a community hangar that has access to anybody and their brother, and even the president of the airport has another set of keys to this plane, but yet they accuse me of possession of a weapon that they say they found in the plane, and they say that, oh, but we never searched the plane. You had an 8-man FBI SWAT team, as they call it, turn upside down or toss the facility. They went through everything, and if we're supposed to believe the FBI is so incompetent that they're going to stand there and walk around a plane with luggage in it with an open door and not search the thing, I find that hard to believe, as well as the fact that the sheriff of the county for all that time did not search the plane. I find that hard to believe. Be that as it may, this court, if it's going to be recognized as a legitimate court, should follow its own rules. And the rules that this court sent me, I complied with by responding with a petition to suppress the evidence of the United States of America, given the fact they had been ordered to provide that evidence. They did not provide it in time. Therefore, I have a right to have that evidence suppressed. And I reassert that now. I've asked that I have the ability to have my hands in shackles so I could go through my files and pull out the information so I could reference it this morning, but that's been denied. I did get a response from the judge that she somehow believes because I've been able to stay awake all night long and print out and type up, not print out, I don't have access to a printer, but because I've been able to handwrite with pencil, and the jail gives you 3 stamps and envelopes a week unless you've got money. My mother is retired and she's 80 years old. She sends me $100 a month that I use for phone calls trying to find legal counsel to get out of here. If you do the math, that doesn't last very long. If you go through the phone book trying to call lawyers, they don't talk for 15 minutes. It takes 15 minutes to get through their receptionist. And then you're talking to them for maybe 10 minutes, and that's $8 to $10 at a whack just to find out that they don't do these cases. So my access to the court or access to counsel has been denied because the cost is exorbitant. There's articles in your newspaper in the Lincoln Star about the cost of phone calls. These counties are making a profit. That's a crime. They should not make a profit off of people being incarcerated. It should be a break-even proposition. But that's another issue that this court and maybe another legislative body can address. But you see, Judge, I don't have access to the court. When I file these few motions, it's all I can do with the little bit of paper that I've got. Without, Mr. Vanderslice did provide me with, and I've still got the empty ones here, 2 little things of paper. And that's it. I'm basically at the mercy of anybody that will donate money to me. And so if the court perceives that somehow or another I've got access to counsel because I've got access to Mr. Vanderslice, they're sadly mistaken, because Mr. Vanderslice is like having no counsel at all. And the record in this court is replete with over 7 different people who he has done the same thing over this past year, where he was appointed, then he withdrew, and then he's appointed as elbow counsel doing the same thing. There's a lawsuit against him where a gentleman was told the wrong thing. He was told that he was able to plead guilty and he would get a small amount of time and a small fine, and then he gets whacked over the head with a huge fine and significant time that he wasn't anticipating. Mr. Vanderslice does not tell the truth. Mr. Vanderslice tells what Mr. Vanderslice wants the court to believe to create its own record. That record in this matter is a fraud. This court shall take judicial notice that I have not consented to any of its unknown operation. If I knew the form of court, then I would know how to proceed. But without knowing the form of court, whether it be admiralty, administrative, constitutional, equity, mercantile, if I knew that form of court, then I would know how to respond. But because I don't know the form of court, I don't know how to respond, because this court is not following its own rules. That tells me it's a kangaroo court. It's an admiralty court.
Do you want appointed counsel? Here is what I've heard in your discussions. You have refused to give me a financial affidavit. However, you have said, I have no money, I have no income or anything to draw from. I receive $100 a month from my mother just to do the postage. I do not have the money to even call an attorney and tell them about my case. I am being denied access to counsel. Do you want, I will consider all of that to be sufficient, even in the absence of a financial affidavit, as that you are entitled to appointed counsel at no cost to you. But you have to tell me whether you want appointed counsel. And so far, you haven't told me that.
Given the fact that this court, Your Honor, you judge, have not advised me of the form of court, and given the fact that I timely filed a motion to suppress following the rules that this court is supposed to be under, and given the fact this court had ordered the U.S. Attorney to supply discovery prior, in 14 days prior to, which would have been the deadline, fell on a holiday, so it fell to the next day, the 2nd. He did not do that. He was instructed to give it
What is the
specifically
answer to my question? Do you want appointed counsel? It's a yes or no question.
Until I know the form of court, I can't answer your question.
And I've told you that it is a court formed under the United States Constitution, Article 3.
Are you operating an admiralty?
This isn't an admiralty case, so I'm not operating an admiralty right now.
What is it?
This is a criminal case.
Right. I asked you before if this was not a commercial crime, and you said no, but under 27 CFR 72.11, this is a commercial crime.
You are charged, and I'll go back to your indictment one more time.
922 little g little 1.
Right.
It's
Felon in possession of a firearm.
in interference with interstate commerce, and that is a commercial crime found under 27 CFR 72.11. I believe I actually sent you a notice about that.
Sir, until you tell me the answer to the question of whether you want appointed counsel, I told you that I have found, based upon your statements that you have made today, and you have made them on the record. You haven't stated them under oath, but I'm going to let that go. You haven't given me a financial affidavit. I'm going to let that go. I'm going to assume you are telling me the truth when you say you have no money, and I am going to assume you're telling me the truth when you say you have no income or anything to draw from, that you are receiving money from your mother simply to make phone calls and do postage, and that you cannot hire an attorney because you have no money. I will assume all of that to be true. I am further assuming and finding that you are not capable of paying for an attorney. So the only question is, do you want me to appoint counsel to represent you at no cost to you?
And again, I cannot answer the question.
And this
that you're
hearing is
asking
complete.
Until I know the form of court that you're operating under.
We are in recess.
All right.
As the marshal is leaving the courtroom, I'm instructing you that, and I see that you have all of the documents that the government has handed to you, along with the flash drive, correct, Mr.? All right. What I'm instructing you to do is make sure that he receives that material. If for any reason Saline County continues to have difficulty with him viewing the videos down there and the audios down there, whether his fault, their fault, I don't care whose fault it is. I just want him to be able to see the stuff, and so I expect you to let me know, and we'll have him brought over to the holding area here, and the court will make sure that he has access to look at the videos and audios. All right?
Yes, ma'am.
Thank you. We are in recess.